video. TikTok's gonna be gone in like a year. So like, is it really that big of a deal? Anyway, now.
Yo no te haré llorar, yo te haré gemir.
Nada de regalos ni pinches perfumitos culeros.
We have Jimenez and Martin. We're just waiting on White. He should be down here any minute.
Okay, no problem.
Just a heads
I can
up.
do White.
Or no, you can do Martin if you want.
Oh, I
So
meant
we're not wasting time.
Yeah, we can have Mr. Martin come in. That's fine.
Fine, sure, no
Yeah,
problem.
thank you.
Mr. Martin, come on in. I can see you.
Like continue at visa time.
Okay. Good morning, Mr. Martin.
Morning.
Okay. So we're here for your preliminary hearing, right?
Yes.
Okay. I have Attorney Jones here from the Public Defender's Office.
Yeah, yep. So Mr. Martin, you indicated that you wanted representation by the public defender's office, okay? But we weren't able to contact you to take your public defender application. Okay, so we weren't able to file an appearance and represent you for today. But I will say that your case is being referred as a top referral, program
Yeah.
referral. And so I would say to you that you should just go forward with that referral as long as you want to participate in that program and not continue your case to have us take your application. It
Yeah,
sounds
that-
like it's, do you agree with that?
Yeah, I had called parole last week and explained. I didn't know this process, so
Okay,
if I would have known that, I would have never even applied for that.
okay. So as long as you're comfortable going forward with that and you know you want to participate in the program, you should do that today and I'll step out of the room so you can have your hearing, okay?
Okay,
All right, good luck, sir.
thank you.
All right, let's do that.
No problem. Thank you. Mr. Martin, so just to confirm, you're okay with going forward today without an attorney, correct?
Yes.
And I'm probably going to ask you that 3 more times, okay?
Okay.
Okay, perfect. So we're ready to get started, all right?
Yep.
Okay, so I am Parole Officer Trusello. I'm a hearing examiner for the Board of Pardons and Paroles. And today is a preliminary hearing concerning William Martin, inmate number 343589. Today is Monday, September 23rd, 2024. And this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Robinson Correctional Institution. Please state your name and inmate number for the record.
William Martin, inmate number 343589.
This is a public hearing and public access to this hearing is available via live stream. Mr. Martin, I am going to swear you in to take some testimony today, okay? Because you're representing yourself, okay? So can you please raise your right hand? You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth. So help you God, or upon penalty of perjury.
I do.
Okay, perfect. So the purpose of this preliminary hearing has three purposes under the Connecticut. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant a revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. Please note that you have been referred by the Department of Corrections for diversion of substance abuse programming and treatment. If by the end of the hearing determine that you should be held in prison pending further proceedings, I will provide the information about the diversion process. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. And this hearing is being recorded. So going over the procedure for the hearing, first I'm going to read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. And then the state is not here. So at the conclusion of the hearing, I will inform you of my findings, which will be based on the available evidence. Also, you will have a chance to discuss the probable cause and the severity of the allegations, okay? Do you have any questions about the purpose or procedure before we begin?
No.
Okay, so you have a few rights that are important for you to know, which I'll review now. So you do have the right to be represented by an attorney at this hearing. You did mention you're okay with moving forward. Is that still the case without one?
Yes, I am.
Okay. You have the right to receive written notice of the charges of violation. Did you receive the written notice?
Yes, I did.
You have the right to review the evidence against you before this hearing. Did you review all your evidence?
Yes, I did.
Okay, and you have the right to submit additional evidence for your case. Did you submit any additional evidence?
No, I did not.
And then at this hearing, you also have the right to call and examine witnesses. Did you want to provide any witnesses for the hearing?
No, I do not.
And do you understand all of these rights, and are you still ready to go forward?
Yes, I do. I am ready to go forward.
So now I'll review the charges that your parole officer, the state, is bringing against you, and the information underlying the charges. So on charge count one, or on charge number one, condition of reporting, the charging officer reported that on August 26, 2024, you failed to report as instructed to the Torrington Police Department at 4:30 p.m. You were a no call, no show. On charge number two, condition of program participation, the charging officer reported that on August 28, 2024, you contacted me from the ICRC detox program after failing to report as instructed. You admitted relapsing and requested placement at the APT Foundation for inpatient treatment. You were then instructed to complete a phone intake and subsequently report to the APT Foundation on September 3rd, 2024 by 11 o'clock a.m., which you failed to do so. On September 3rd, 2024, after you failed to report to the APT, you were instructed to report to APT on September 4th, 2024, of which you failed to do so. On September 5th, 2024, you finally reported to APT, but were negatively discharged from the program after cocaine was discovered on your person. Due to your negative discharge from the program, you can no longer participate in the APT Foundation inpatient program as instructed. On charge number three, conditions of obedience to the law, the charging officer reported that on September 5th, 2024, at approximately 5:40 p.m., staff at the APS Foundation received reports from other residents that you were in possession of narcotics within the program. Following an investigation, staff discovered a small bundle of white powder on your person. You subsequently admitted that the substance was cocaine. As a result of your actions, you were discharged from the APS Foundation, and the Connecticut State Police were contacted, who are currently pursuing an arrest warrant for possession of narcotics. And on charge number 4, conditions of drugs, the charging officer reported that on September 5th, 2024, the APS Foundation staff investigated and discovered a small bundle of white powder on your person. You subsequently admitted that the substance was cocaine. On September 6, 2024, you signed a voluntary admission indicating that you used illegal substances within the past 72 hours. The state has filed the following exhibits pre-marked for identification purposes. Exhibit A, a notice of parole violation. Exhibit B, parole violation report. Exhibit C, remand to custody order. Exhibit D, signed conditions of parole. Exhibit E, the APS Foundation incident report. Exhibit F, pictures of white powder found on your person at APT. Exhibit G, the Connecticut State Police report number 24003399093 when completed. Exhibit H, screenshots of the text messages to Mr. Martin instructing him to report on August 26, 2024 at 4:30. And Exhibit I, a signed voluntary admission form. Mr. Martin, one more time, did you receive the notice of the violation report, the parole violation report, and any of the other documents that I just listed as exhibits?
Yes, I did.
Do you need to continue this case for any reason at this time to obtain additional evidence?
No, I do not.
Today we have no witnesses. So right now, Mr. Martin, it is your opportunity to respond to the parole violation charges against you. However, remember that you may remain silent if you choose to do so. And at this time, you may testify regarding your case. Would you like to respond to any of the charges?
I'm just going to remain silent.
So I'm going to move on to announce my findings. Last chance, any additional information you want to provide, or you're still okay to move forward?
I'm okay to move forward.
So let me just review all of the stuff I have, okay? All right. So I'm going to notify you first on my findings of probable cause. So on charge number 1, I find that you violated the condition of reporting based on the evidence in support of the charge. And that's Exhibit B, the parole violation report dated 9/16/2024, which includes information about the August 26, 2024 date when you failed to report to your appointment. Exhibit D, the parole conditions signed by you in 9/16/2023, which indicate that you had knowledge of the said conditions, specifically under release direction where it states and follow the parole officer's instructions. And Exhibit I, the screenshot of the text messages between you and Officer Kwasnick instructing you to report on August 26, 2024 at 4:30 p.m. On charge number 2, I find that you violated the condition of program participation based on the evidence in support of the charge, which includes Exhibit B, the parole violation report dated September 16, 2024, which includes information about your request to be placed in the APT Foundation for inpatient treatment, as well as the 2 missed dates for your admission and subsequent negative discharge from the program. Exhibit D, the parole conditions signed by you on November 16, 2023, which includes that you acknowledge the said conditions, specifically release direction, where it states, I will be assigned to one of several levels of community supervision and agree to participate in programs as determined by the parole officer. On charge number 3, I find that you violated the condition of obedience of law based on the evidence in support of the charge, which includes Exhibit D, Again, the parole condition signed by you on November 16th, 2023, which includes or indicates that you acknowledge the conditions, specifically release direction, where it said, I will be assigned to one of several levels of community supervision and agree to participate in programs determined by the parole officer. Exhibit E, the APS Foundation incident report dated September 5th, 2024, which includes details regarding the discovery of you being in possession of drugs after it was reported that you had them and were using them in the bathroom. And Exhibit G, the Connecticut State Police report dated number 24003399093, dated September 5th, 2024. And although this is a draft, it depicts the behavior of you being in possession of drugs in the APT Foundation. And on charge number 4, I find that you violated the conditions of drugs based on the evidence in support of the charge, including Exhibit D, the parole conditions signed by you on November 16, 2023, which indicate that you had knowledge of the said conditions, specifically obey all laws, where it states, I will not use or have in my possession or control any illegal drugs, narcotics, or drug paraphernalia. Exhibit E, the APT Foundation incident report dated September 5th, 2024, which includes details regarding the discovery of you being in possession of drugs after it was reported that you had drugs and was using them in the bathroom. Exhibit G, the Connecticut State Police report, number 24003399093, dated September 5th, 2024. And although this is a draft, it depicts the behavior of you being in possession of drugs at the APT Foundation. And Exhibit I, a voluntary admission form signed by you on September 6, 2024, stating that you last used cocaine and fentanyl on September 5th, 2024. I find that the acts are serious enough to warrant a revocation, and I have also determined that you should be detained while you wait for your revocation hearing. However, the Department of Corrections has recommended you for diversion from the revocation process for substance abuse programming and treatment. This means if you wish to participate and apply, and I find that you meet the certain eligibility criteria, I can continue your case while you are provided an opportunity to participate in substance abuse programs and treatments in the correctional facility. If you successfully complete the program and treatment provided, I will dismiss your case and order your parole reinstated. If you do not complete the program and treatment provided, the board will schedule and convene a revocation hearing to determine if you violated the conditions of your parole. If so, the hearing examiner will make a recommendation regarding whether your parole should be revoked and what, if any, sanctions should be imposed. The decision to participate in a diversion program is voluntary. Do you understand the diversion process and do you wish to apply for it?
Yes, I do.
Okay, so now we're going to go over, I'll now ask my findings with respect to your eligibility. If I determine, okay, so we have to go over your findings with your eligibility for the program, okay? If I determine that you are eligible, I can accept your application and I divert you from the revocation process, okay?
Okay.
Do you have anything else to add at this time before we move forward?
Oh, no, not at this time.
Okay. So I've reviewed all of the relevant information and the findings are as followed. I find that you have no pending misdemeanors or felony charges. I find that your discharge date is December 24th, 2024, which is more than 60 business days from the date of your remand to actual custody. I find that there is evidence that you have identified a substance abuse treatment need. I find that substance abuse is reasonably considered to be a motivating factor in your alleged failures to comply with the terms of your conditions of parole. And I find that there is some evidence that you received or were provided with an opportunity to receive substance abuse programming or treatment during a period of parole supervision in the community. So I have determined then that you are eligible for the diversion for substance abuse programming and treatment. Before I accept your application for diversion, I ask that you indicate whether you understand the following by answering yes or no. So it is, I understand that I will remain incarcerated while I receive programming and treatment, and that parole revocation proceedings may be delayed as a result. So you
Yes.
understand?
I understand.
Okay. I understand that the dismissal of my case and reinstatement to active parole supervision is not guaranteed and is conditioned upon my successful completion of substance abuse programming and treatment.
Yes, I understand.
Perfect. I understand that ultimately the Department of Corrections will determine whether I have successfully completed the substance abuse programming and treatment provided.
Yes, I understand.
Perfect. And lastly, I understand that my participation in this program is completely voluntary.
Yes, I understand.
Great. Okay, Mr. Martin. So as of right now, today, your application for the diversion is granted. You will be placed, I think you're already in it though, correct? You've started
Yes.
it? Okay,
Yes.
so you will continue in the treatment and programming by the Department of Corrections and diverted from revocation for no more than 60 business days, okay? So
Yes.
as long as you complete that program, they'll let you back out and you can keep doing better in the community, okay?
Yes, thank you.
All right, so we are all set. Do you have any questions for me, Mr. Martin?
No,
No? Okay, great. Then good luck, okay?
thank you.
This concludes the preliminary hearing, and I'm now going off the record. Thank you.
Oh,
Thank
that was a
you.
little bit too loud right there. Hopefully I didn't wake anybody up. Anyhow, good morning to everybody that's joining in right now. I was trying to set up the TikTok account, but for some reason the audio is off on the TikTok. I'm not sure. I was trying to figure it out, but I guess
Hello.
I'll try to
Do you
do that.
like Jimenez or White?
Let's go with White, because I think I need to wait for Jimenez's attorney.
No problem. Sounds good.
Perfect. Thank you.
No problem. White, you're up.
Next. How's everybody doing today? Good morning, and I'll be streaming for like about the next 3 hours before I go to work. So we'll see what we got coming in today. All right, so on this next gentleman, what do you guys think? Do you guys think he's going to be found suitable for parole? Denied? What are your thoughts on it?
Okay. Good morning, Mr. White.
Good morning.
I am Parole Officer Trusello, and I'm a hearing examiner for the Board of Pardons and Paroles. And this is a revocation hearing concerning Dwayne White, inmate number 227845. Today is Monday, September 23rd, 2024, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Carl Robinson Correctional Institution. Please state your full name and inmate number for the record.
I'm Dwayne White, 227845.
This is a public hearing. Public access to this hearing is available via live stream. Present this morning also are Attorney Jones. Can you please identify yourself for the record?
Yes, thank you. Attorney Sonia Jones, Public Defender's Office Parole Revocation Unit on behalf of Mr. White. And also present and seated behind me is Attorney Hannah Dean from my office, just observing.
Yes, ma'am.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by the preponderance of evidence. That is, the better or weightier evidence must establish that, more probably than not, that the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to the appropriate sanction. My recommendation will be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that the revocation hearing is an adversarial proceeding. Anything you say at this hearing can be used against you, and this hearing is being recorded. The testimony at today's hearing will be conducted under oath. Would you like me to swear him in?
I I don't anticipate him having to testify,
Okay, so you'll let me know?
yes.
Okay. All right, so we're going to go over the procedures of the hearing. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if you have violated one or more of the conditions of your parole, you will have the opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am. No, ma'am.
So you have rights for this hearing, and I will review them with you now. You have the right to be represented by an attorney at this hearing, and you have counsel here today representing you. You have the right to receive written notice of the charges of violation. Did you receive the written notice?
Yes, ma'am.
You have the right to review the evidence against you before this hearing. Did you have time to review the evidence?
Yes, ma'am.
And you have the right to submit evidence in support of your case.
You should have received exhibit 1, list of parole accomplishments and future plans for parole reinstatement.
Good morning.
But you
Good
would have
morning.
received it for the original hearing date, so I don't know if that.
Okay, got it. Okay.
Yep.
So I'm just gonna take a second quickly just to review it because I didn't go over it.
Is this live? Yes, it is. It is live. And good morning to everybody on TikTok and on YouTube. We got 169 viewers on TikTok. We'll see if that stays like that. And on YouTube, I think we got like about 7 or 8. If you want to see the video feed, I would suggest for you guys to jump over to our YouTube channel at Collect Call From, and you could see the live feed. Unfortunately, gracias. Good morning to you. My live access on my desktop has been restricted until sometime later on today, and in the future I probably won't be doing the live video feed on TikTok because it seems like it's causing a lot of issues with my account getting restricted and whatnot. So
Sorry about that. All right. Also back to your rights. You also at this hearing have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yep.
Yes, ma'am.
I'm now going to review the charges that the state, your parole officer is bringing against you and the information underlying each charge. On charge number 1, condition of release direction program participation, the charging officer reported that you were unsuccessfully discharged from the Explore program and Wheeler Clinic in Hartford on January 4th, 2024. You accrued absences on the following dates: December 7th, 2023, December 14th, 2023, December 21st, 2023, and January 4th, 2023. You were unsuccessfully discharged from the Explore program with Wheeler Clinic in Hartford on March 20th, 2024. You accrued 4 absences on the following days: January 24th, 2024, January 31st, 2024, February 28th, 2024, and March 20th, 2024. On charge number 2, condition of obey all laws, the charging officer reported that on May 14th, 2024, you were observed as a driver of a vehicle with individuals who committed a larceny at Poles located in Manchester, Connecticut. Manchester police conducted a motor vehicle stop and you were subsequently arrested and charged under Connecticut General Statute number 53A-125, larceny in the 4th degree. A $10,000 bond was set for your release, and as a result, you were in violation of condition number 2, obey all laws. On condition number 3, obey all laws, drugs, the charging officer reported that on January 8, 2024, you rendered a urine screen that was sent to Premier Biotech Labs to test for substances. On January 13, 2024, Premier Biotech Labs confirmed that you were positive for cocaine and fentanyl, and as a result, you were in violation of condition number 2, OBEO laws. On January 8, 2024, you signed a voluntary admission on January 8, 2024, reporting that you had used ecstasy. As a result, you were in violation of condition number 2, OBEO laws. On charge number 4, conditions of additional conditions, behavioral management programs, the charging officer reported.
What did he report? Hello.
Reported that you were unsuccessfully discharged from the Explorer program with Wheeler Clinic in Hartford on January 4th, 2024. You accrued absences on the following dates: December 7th, 2023, December 14th, 2023, December 21st, 2023, and January 4th, 2023. As a result, you are in violation of the additional condition that stipulated that you participate in the behavioral management program for domestic violence.
Oh.
You were unsuccessfully discharged from the Explorer program with Wheeler Clinic in Hartford on March 20th, 2024. You accrued 4 absences on the following dates: January 24th, 2024, January 31st, 2024, February 28th, 2024, and March 20th, 2024. As a result, you were in violation of the additional condition that stipulates you to participate in a behavioral management program for domestic violence. The state has filed the following exhibits pre-marked for identification purposes as Exhibit A, the Connecticut Conditions of Parole; Exhibit B, the Connecticut Board of Parole Remand to Actual Custody Order; Exhibit C, Notice of Parole Violation, Notice of Parolee Rights; Exhibit D, Parole Violation Report; Exhibit E, the Manchester Police Department Arrest Profile; Exhibit F, the Manchester Police Department case number 24-26088; Exhibit G, the State of Connecticut Superior Court Criminal Bond Appearance; Exhibit H, the State of Connecticut Superior Court Notice of Rights, bail, Notice of Rights bail; Exhibit I, Explorer Discharge Report; Exhibit J, the Premier Biotech Lab Report; Exhibit K, the Voluntary Admission; and Exhibit L, the Misconducts. The state submitted an additional piece of evidence, which I move to remark and include as Exhibit M, which is a disciplinary report dated August 12th, 2024. The state also filed an addendum to the parole violation report, which is admitted into evidence and reads as follows. Per GA 12, docket number H12M-CR24-0295570-S for Connecticut General Statute number 53A-125, larceny fourth. Mr. White pled guilty and the case was disposed on August 13, 2024, which he was sentenced to unconditional discharge. Please be advised that Mr. White was issued a Class A ticket for security tampering at Carl Robinson on August 12, 2024. Mr. White pled guilty, and please see attached DR under parole violation evidence. Did you receive the notice of the parole violation, the parole violation report, and any other documents I just marked for identification purposes?
Yes.
Do you need more time to review any of the information?
No.
The defense has also filed exhibits, and I will remark them as, maybe not remark them. I'm going to mark them as Defense Exhibit 1, the list of parolee accomplishments and future plans for parole reinstatement. Yeah, do you need time to continue this hearing for any additional defense evidence?
No.
We have no witnesses today. And at this time, it is now the defense's opportunity to call any witnesses, present evidence, and speak to any of the evidence submitted.
Thank you. I just have comments in regards to the charges. In regards to charge 1 under program participation, addressing the first portion of that charge. I would just note that on January 16th, my client was issued a misconduct for that alleged conduct and referred back to programming. And he does maintain that he missed some of those dates because of his work schedule, and that he was working third shift. I believe that was confirmed employment. He was working from 6 p.m. to 7 a.m. and the program start time was 2:45 p.m. So he was having difficulty with his work schedule as well as that programming. In regards to charge 2, obedience to the law, I would note that he was the subject of an arrest on that May 14th of 2024 date, that he was originally issued a non-surety bond, and that it was our office that notified the court that they needed to do a habeas to bring him to court. He did resolve that matter by way of an unconditional discharge, as you indicated that the addendum was stated correctly. In regards to charge 3, drugs, it was my client who self-reported that after the passing of his mother, that he made a bad decision. He did take an ecstasy pill. And then it was because of his self-reporting that he was then drug tested by his parole officer. He does maintain that he did not intentionally ingest cocaine or fentanyl. And that's why he did self-report that he had taken that ecstasy pill. That was in January. He was remanded in May. He was issued a misconduct for that conduct and served a sanction successfully for that. In regards to charge 4 under behavioral management program, that charge is completely duplicative of charge 1. And so my comments in regards to charge 1, I would ask that you just adopt those same comments. Nothing further as to the charges.
All of that
Good
information
morning.
was noted.
So anybody wants to catch the video stream, I also have it running on YouTube, and you could actually see the gentleman on the screen. What do you guys think? You guys
So
think?
I am going to move forward with my findings. Before I do that, counsel, is there any closing statements you'd like to make?
Nothing more in regards to the charges.
Do you guys think he's gonna be found suitable for parole? What's your guys' thought on it? So I think my account's gonna get lifted off of the restrictions sometime today. So
on charge number 1, I find that you violated the condition of release direction, specifically program participation, based on the evidence provided in support of the charge. Exhibit A, the parole conditions that were signed by the parolee on October 19, 2023, indicating your acknowledgement of the said conditions, which include a domestic violence program participation condition. Exhibit D, the parole violation report, which includes information regarding the parolee's 2 unsuccessful discharges from the Explore Domestic Violence Program, largely due to repeat absences. Exhibit I, the 2 Explorer discharge reports with discharge dates of January 4th, 2024 and March 20th, 2024, both which indicate that the parolee was unsuccessfully discharged largely in part due to repeat unexcused absences. And Exhibit L, the misconduct dates on January 16, 2024 and April 24, 2024, both of which indicate his unsuccessful discharge from the Explorer program due to missed sessions. The misconduct dated January 16, 2024 further indicates that the parolee was instructed by the parole officer to follow the program recommendations and expectations.
things ain't looking good.
Charge number 2, I find that you violated the condition of bail laws based on your conviction of the larceny fourth on August 13, 2024. Along with the following evidence in support of the charge. Exhibit A, the parolee signed conditions that were signed by the parolee on October 19, 2023, indicating your acknowledgement of the said conditions, which includes obey all laws. Exhibit D, the parole violation report, which includes details regarding the parolee's criminal offense, arrest, and subsequent conviction for the larceny fourth on August 13, 2024, which he received an unconditional discharge. And Exhibit F, the Manchester Police Report dated May 14, 2024, which includes detailed information related to the parolee's criminal behavior and subsequent arrest. On charge number 3, I find that you violated the condition of obey all laws, specifically drugs, based on the evidence provided in support of the charge, to include Exhibit A, the parole conditions that were signed by the parolee on April 16, 2024, indicating your acknowledgement of the said conditions, which include the parole that the parolee was not to possess or use illegal drugs. Exhibit D, the parole violation report, which includes details regarding the parolees testing positive for and admitting to using illegal drugs. Exhibit J, the Premier Biotech lab results from the parolee with the collection date of January 8th, 2024, which includes positive results for cocaine and fentanyl. Exhibit K, the voluntary admission that was signed by the parolee on January 8th, 2024, indicating his admission to use ecstasy. Exhibit L, the misconduct dated January 8th, 2024, that was issued to and signed by the parolee on January 26th, 2024, with regards to his positive drug test and admissions to using ecstasy. On charge number 4, I find that you violated the condition of additional conditions, specifically behavioral management programs, based on Exhibit A, the parolee's conditions that were signed by the parole conditions that were signed by the parolee on October 19, 2023, indicating your acknowledgement of the said conditions, which include a domestic violence program participation condition. Exhibit D, the parole violation report, which includes information regarding the parolee's 2 unsuccessful discharges from the Explore domestic violence program, largely due to repeat absences. Exhibit I, the 2 Explore discharge reports with discharge date of January 4th, 2024 and March 20th, 2024, both of which indicate that the parolee was unsuccessfully discharged, largely in part due to the repeat unexcused absences. And Exhibit L, the misconduct dated January 16th, 2024 and April 24th, 2024, both of which indicate his unsuccessful discharge from the Explore program due to missed sessions. The misconduct dated January 16, 2024 further indicates that the parolee was instructed by the parole officer to follow the program recommendations and expectations.
Damn, son.
So this concludes the fact-finding portion of this hearing. Before I make my recommendations, you have the opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I will recommend.
Thank you. Thank you. My client is 48 years of age. He's married. He has 7 children. 2 of those children are minor children. He has a 10-year-old and a 14-year-old. He was in the community for approximately 15 months prior to his remand to custody. And during this period of supervision, my client was living in a halfway house in Middletown. He then transitioned to the Chrysalis Center in Hartford, where he remained until his remand. He was working at FHS warehouse in Manchester, also working at Humano warehouse in Manchester. His job duties included packing jacks, driving jacks, and picking up pallets. He maintained full-time employment and was able to pay for his apartment as well as support his minor children. Upon being re-paroled, he would like to be sponsored at a halfway house in the Hartford area due to the proximity to his wife. He indicates he can return to his employment at Humano in Manchester. He would like to obtain his GED as well as obtain an OSHA certification if he's released back into the community. He is very eager to reunite with his wife as well as his children. He indicates he's amenable to all treatment recommendations, and obviously that's inclusive of completing the Explorer program. I would note that the recommendation of the parole officer is that he remain incarcerated until he completes the disposition of his GA-12 case, which is he received an unconditional discharge on that case, and that case was disposed of. The PO indicates this is his fifth violation of his parole, and I would just point out that I would see this as his third violation of parole. As 2 of those prior violations, he was referred to the top program. He completed that program successfully, and I don't believe those violations then should be counting against him in this situation. My client is due to end his sentence on January 28th of 25 with no period of supervision to follow. He could benefit from parole supervision to the extent that he'll need assistance securing housing as well as appropriate programming. A re-parole date prior to his EOS date will be in line with the recommendation of his parole officer. It will benefit my client, and in my assessment will also benefit the community, as he will leave DOC with some structure in place. So we are asking that he be re-paroled at the next available date. Thank you.
Yeah, that's his. I believe.
Thank you.
That's. I believe
so
that's his
all the
lawyer
information
speaking.
just provided is noted. I am going to take a few moments right now just to review additional information before I move on. to my recommendation.
So what do you guys think? Do you guys feel like he's gonna be granted parole? This is his what is it? His fifth violation? Damn. Hey, but it sounds like he had a good night that
If I could
night.
just make one more note, I apologize. I would just also point out that my client was, I had that he was paroled on March 10th of 23. And I would just note that during that time period, up until remand, he was consistently being drug tested. And it was only that after the passing of his mother and him making a bad decision in regards to substances, he self-reported that to his parole officer. And at no other time had he provided a dirty urine. And in my opinion, had he not self-reported that situation and was forthcoming with his parole officer, perhaps that would not even have come to light. And again, as I indicated, he was issued that misconduct and he served that sanction. That's it. Thank you.
Bad decision. It was a
Thank
bad
you.
choice. Decision. Come on now. He looks like he's up there in age. Should be able to tell the difference between right and wrong and whether he wants to violate his parole or not. Or am I just being a little bit too harsh? I don't know. I mean, if I didn't want to get incarcerated, I definitely wouldn't be violating parole. Hell nah. What do you guys think? I'm definitely interested in your guys' point of view. And if you want to catch the video feed of this, we actually got it running also on YouTube. My TikTok account got restricted last Friday for 3 days, so the restriction gets lifted today. But I don't think I'm gonna be going back to the feeds and whatnot because it's causing a lot of issues. So M-Star Media, Facts, James. Let me see what's being said over here on TikTok. And I appreciate you guys that come back day after day for these streams. Let's see what it is.
So I am going to move forward with my recommendation. Mr. White, I recommend that your parole be revoked and that you serve an approximate 8-month and 2-week period of confinement as a sanction. That's a revoke with a no new re-parole date, and your special parole term is set to end on January 28th, 2025. This is based on 2 prior special parole violations, 1 technical and 1 criminal involved absconding. You have been diverted to TOP twice in 2019, and I do acknowledge that you were in the community for 1 year and 2 months. However, during that period, you were issued 3 misconducts for drug use and being unsuccessfully discharged from the Explorer program twice. Also, you were arrested for the theft-related offense from a store, and you were convicted of larceny 4th. So the evidence indicates that serving special parole for your prior robbery, that you were serving the special parole for your prior robbery first conviction, and your current conviction indicates a continued pattern of the theft-related behavior. So in the event that the board, this recommendation is going to be forwarded to the board, and in the event that the board decides to lessen my recommendation, I recommend that following conditions be stipulated. So the behavioral management program for domestic violence, no contact with your co-defendants, Myra Williams and Timothy Reynolds, no contact with your co-defendant, Jovan Bartel, without your parole officer's permission, no contact with the victim PP, a general no contact with Melissa Slaughter or Coles in Manchester, Connecticut, a halfway house placement, and you mentioned Hartford, correct?
Yes.
In Hartford.
Hartford.
And no operation of a motor vehicle without your parole officer's permission. So my findings and the recommendations will be forwarded to the board, and you should receive on October 3rd, 2024, and you will receive the official written decision from the board following that date. If the board may lessen my recommended sanction, and the board may let my recommended sanction stand, and they will decide that on that day. And like I said, the notice will be sent to you, okay? Do you have any questions before I conclude my hearing?
I do not. Mr. White, if you have any questions, you can contact me, okay?
Okay.
You should do so after the October 3rd date. That way I can tell you what the board ultimately decided, okay?
Okay, ma'am.
Okay.
Okay, this concludes the revocation hearing, and I'm now going off the record.
That
We are all
was,
set. Thank you, Mr. White.
Thank you.
He couldn't really. I mean, what can he say about him getting denied? It was pretty much cut and dry. Hey, what's up? Hey, how's it going, Mad Max? We got Mad Max 408 on YouTube. We also got M Star Media. Hey, thank you guys for the support. Really appreciate it. We also got
Good.
Bone.
Ready for Mr. Jimenez?
Yup.
Yes, you can send them in, please. Thank you.
Shoot him. Man, they're definitely not wasting any time today. And coming in, strolling in, see what it is today. So what do you guys think? All right, let's get a poll going over here. What do you guys think? You guys think he's gonna be found suitable for parole? Definitely interested in hearing what you guys have to say. Can you put it on the screen? Stevie B, unfortunately, they restricted my account last week on Friday. So right now, I'm not able to use the TikTok Live software or Studio to be able to put it on the screen. So, but I am running it on YouTube. If you jump over to our YouTube side, which is at Collect Call From, we do have a live feed going on over there, and you could check it out over there. If you're on TikTok, it's only going to be the audio for right now. Till I figure some things out, and also they have to lift the restrictions of my account. You know, they've been hard on me. All right. Let me see here. Let me get the poll going right here on TikTok. How do I get the poll going? I always forget. It's the text poll. And would he be found suitable for parole? We don't know anything yet. They haven't announced any of his charges or any of his violations. So they should be continuing with this hearing momentarily here. And for any of you that are on the TikTok side that are wondering what's those messages on the screen, those would be the messages on from the TikTok side. So like that, you guys are able to get from both worlds. Let me see here. Hey, Luz, how's it going? Hey, thank you for jumping over from the TikTok side over to the YouTube side. Let me see, who else do we got over
We'll be
here?
right with you, okay, Mr. Jimenez?
Jimenez.
Yep.
Hey, thank you. Hey, Jonathan, thank you for coming over. James, I came over from TikTok. Glad YouTube lets you show them TikToks. Yeah, it does sometimes, It's I like it because it's I like TikTok because it's relatively quick. You're able to get out information immediately, but sometimes the restrictions I think are a little bit heavy-handed, if you will, if I'm using the correct word. But I mean, it is what it is. You just got to kind of figure out how to maneuver and get around these things, and that's why I'm running a simultaneous stream, if you will. Let me see. Gene Bean, hey, good morning. Welcome to the YouTube side. And let me see. Hey, Rudy, thank you for the follow. Lang Time Cooley, thank you for the follow on the TikTok. And Miss Bottom, thank you for the share on the TikTok side, if you will. Let me see what else we got out because I don't want to miss anybody. I definitely appreciate you guys tuning in. Let me see, Rick James. I can't even say the rest of the name, but I thank you for the follow. Let me see. Mandy Mitch 760. Hey, what's up? How's it going? All right, and I'm just kind of going up the chat on the TikTok side. 30 twin here. That's awesome, James. Hey, that's what I'm talking about right there. Gene Bean had to leave T. Yeah, it is. The only difference between TikTok and YouTube is that on the TikTok side I show my face. Not that I want to show it, but I got no choice. And then on the YouTube, I'm showing the actual live board of parole hearing today. You know what? There wasn't that many board of parole hearings going on today. You know what? I gotta. I'll be right back. I'm gonna get off the screen for a moment. I gotta turn on. I'm gonna do the stream from Utah. They should be starting that right about now. So I'm gonna go ahead and get that going, and I'll be right back. Mad Max 408, we know what you look like. It's okay. Hey, Mandy, hey, thank you for coming over from the TikTok side. Highly appreciate it. Jumping over to YouTube. And let me get. I'm gonna test out my my sound effects over here. Make sure they're not too loud. Let me know if they're too loud, or should I lower them? Is that too loud, or should I lower it a bit? I'm not trying to wake anybody up or scare abuelita. That'll be no bueno.
I'm here.
Good morning, Officer Pearson. Thank you for joining with us.
Good morning. How are you doing?
Good. Okay. Good morning. I am Parole Officer Tricello, and I'm a hearing examiner for the Board of Pardons and Paroles. And this is a preliminary hearing concerning Michael Jimenez, inmate number 318215. Today is Monday, September 23rd, 2024. And this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Carl Robinson Correctional Institution. Please state your name and inmate number for the record.
Michael Jimenez, 318215.
This is a public hearing, and public access to this hearing is available via video live stream. Present this morning also are Attorney Famiglietti and Parole Officer Pearson. Famiglietti.
Good morning, Attorney Robert Famiglietti of the Public Defender's Parole Revocation Unit. Hello, sir.
How you doing?
I'm well, sir. How are you?
I'm doing fine.
Good.
And Officer Pearson, can you please identify yourself for the record?
Clyde Pearson, parole officer for residential unit in Hartford.
This is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there is a probable cause to believe you committed an act that violated the conditions of your parole. Then to determine if the act is sufficiently serious to warrant the revocation of your parole. And then to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. The hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Jimenez and Officer Pearson, can you please raise your right hands? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
I do.
We're going to go over the procedures for the hearing. So first, I'm going to read your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. And then I will review and identify exhibits filed for the record. The state will then have the opportunity to address the issue of probable cause and the severity of the allegations. And after the state is finished, you will have the same opportunity. At the conclusion of this hearing, I will inform you of my finding, which will be based on all of the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, I don't.
So you have a few rights to this hearing, and I'm going to review them all with you. The first is that you have the right to be represented by an attorney at this hearing today, and you do have counsel here with you. You also have a right to receive written notice of the charges of the violation. Did you receive your written notice?
I did.
You have the right to review the evidence against you before this hearing, and you have the right to submit evidence in support of your case. At this hearing, you also have a right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand all of these rights?
Yes.
We're now going to review the charges that the state, your parole officer, is bringing against you and the information underlying the charges. On charge number 1, condition of release direction, specifically GPS, Mr. Pearson, the charging officer, reported the following. Can you please read it?
On July 27th, 24, you reported the Hartford Parole District to meet with this PO. On said date, you read and signed your GPS monitoring agreement and was placed on GPS monitoring. On 8/11/24, you cut off your GPS strap off your ankle and placed it on, On August 11, 2024, you cut your GPS strap off your ankle around 9:26 p.m. and tossed it on Alden Street in Hartford, Connecticut. You are in violation of your GPS monitoring agreement, which states I will remain on GPS monitoring for a length of time determined by parole officer and will not remove the GPS tracking device or strap from my ankle without prior permission from a parole officer.
Thank you. And on charge number 2, condition of release direction residence, Officer Pearson, can you please read the violation details?
On the following dates, August 11th, 12th, 13th, 14th, 15th, 16th, 17th, 18th, 19th, and 20th, you did not stay at your parole-approved residence of 115 Weathersfield Ave, Hartford, Connecticut, 06114. You did not have permission from parole officer to change residence or location, and you did not plan on returning due to extended time at unapproved address and failing to return this PO's messages and calls. On aforementioned dates, you were residing with Derica James' home located at 116 Hillcrest Ave, Apartment D, West Hartford, Connecticut, 06110. On August 20th, 2024, parole found you at Ms. James' home and remanded you into custody.
On charge number 3, obey a law, specifically drugs, charging officer reported.
On August 20th, 24, you reported to parole that you had used $300 to $400 worth of crack cocaine each day on August 11th, 12th, 13th, 14th, 15th, 16th, 17th, 18th, 19th, and August 20, 2024.
And on charge number 4, conditions of additional conditions, specifically halfway house placement, the charging officer reported.
On June 4th, 2024, you were given a community pass to attend Best Chance from 1:30 to 4 p.m. You left the program early at 2 p.m. At 3:45 p.m., Halfway House staff observed you walking up Grand Street with a former resident of CPA Halfway House. You reported you were helping previous offender bring groceries to his apartment. You are in violation of your Halfway House agreement, which states, I will only go to locations on an approved community pass unless changes have been authorized by staff. On June 22nd, 2024, you were given an approved community pass to attend Walmart from 1 to 5 p.m. Instead of going to Walmart, you were lying in bed with Derica James. Pictures in your phone with a timestamp was at 1:26 p.m. You confirmed going to your girlfriend Derica James' home. You are in violation of your Halfway House agreement, which states, I only go to locations on an approved community pass unless changes have been authorized by staff. On June 30th, 2024, you were given an approved community pass from CPA Halfway House to attend Shiloh Baptist Church. You signed out at the Halfway House at 9:02 a.m. and returned at 1:14 p.m. Instead of going to church, you went to Miss Greeby's pool with her. The timestamp on your phones for said pictures of pool and offender, and there was a picture of you in the lounge chair at her pool, were at 10:22 a.m., 11:12 a.m., and 11:29 a.m. You confirmed not going to church with this PO. You are in violation of your Halfway House agreement, which states I will only go to locations on an approved community pass unless changes have been authorized by staff. On July 5th, 2024, you were given an approved community pass from CPA Halfway House to attend Best Chance at 11:15 a.m. to pick up your check. You then came back to the Halfway House and signed out for work at Capstone from 5 p.m. to 5 a.m. In your phone, you videotaped another female in the kitchen of her home.
Damn.
The timestamp on the video was 11:04 p.m. on 7/5/24.
Damn,
you should have been at work. You confirmed being with Kristen Greeby's home to this PO. You are in violation of your Halfway House agreement, which states I'll only go to locations on an approved community pass unless changes have been authorized by staff. On August 11th, 23, You voluntarily exited your parole-approved residence, Cheney Halfway House, located at 155 Weathersfield Ave, Hartford, Connecticut, 06114, and you did not return. You did not have permission to leave the halfway house, and you failed to contact the halfway house or parole at any point thereafter. This PO called your cell phone at 860-985-2436 at 9:49 p.m. and informed you to return to the halfway house right away and to contact this PO or a warrant will be filed for your arrest. You failed to return this PO's calls and messages to you. This is a violation of your halfway house agreement, which states I will not leave the physical confines unless authorized by program staff or parole.
Thank you. Okay, and then the state has filed the following exhibits. Officer Pearson, can you please list all the exhibits you have provided?
So Exhibit A, remand to actual custody. Exhibit B, parole conditions dated 5/10/24 and 7/22/24. Exhibit C, halfway house agreement dated 5/10/24 and 7/22/24. Exhibit D, notice of parole violation. Exhibit E, notice of parolee rights. Exhibit F, parole violation report. Exhibit G, residential discipline report dated 6/4/24. Exhibit H, offender misconduct report dated 6/4/24. Exhibit I, incident report dated 6/4/24. Exhibit J, incident report signed 7/22/24. Exhibit K, offender misconduct report dated 7/24/24. Exhibit L, GPS monitoring agreement dated 7/24/24. Exhibit M, Allied Universal EM Manager, cut GPS. Exhibit N, picture of GPS being between two buildings after being cut. Exhibit O, voluntary admission of positive test results for prohibited substance. Exhibit P, screenshots of offender's cell phone deviating from past 5 times.
Thank you. Mr. Jimenez, did you receive the notice of parole violation, the parole violation report, and the other documents that have been listed for identification purposes?
No.
Did we go over those?
All I got was the violation report. I didn't get none of the documents, none of those evidences, none of those exhibits. I didn't receive any of those exhibits.
That's correct. On September 6th, we spoke and we went over all the preliminary hearing talking points, correct?
Yes, we did.
We went over the charges, correct?
Yes, we did.
Okay, but you didn't receive all the elements. In other words,
No.
all the exhibits, correct?
Correct.
Okay, thank you.
Are you okay to move forward without having that, or would you like more time for him
It's
to?
my understanding that none of the clients receive all of the exhibits prior to the hearings.
Okay. Okay, as long as.
Sorry, would you like a copy of all of the exhibits prior to your hearing?
No, we can move forward. No.
Okay.
That's not really it. Yeah.
Okay, thank you.
He knows he's done.
The defense has also filed exhibits pre-marked for identification purposes. We have Exhibit 1, which is a letter of support from Derica James, and Exhibit number 2 is also an additional letter from a letter of support from Miss James. So we went over that first. So there's no witnesses for today's hearing, correct?
Correct.
Okay.
Other than the, well, yeah.
Excuse me. Can I say
Yes.
something about those exhibits?
Sure.
So I just want the board to be known that Derica James is not a forensic case manager for the Department of Corrections. She works for CRT. She helps with our placement in our scatter site beds for offenders, which Jimenez would be potentially able to go to one in the future. She would oversee his placement in the bed. So I think it's inappropriate that she's providing this letter of documentation in support for him, and in the fact that he did find him at her residence.
I will note that for the record.
That makes no sense whatsoever.
It's still going to be considered, sir. It's just it's just the witness, Mr. Pearson, just wanted to clarify that something that was represented. Please, I don't want to speak for you, sir, but I believe what he's saying is that something that was represented in the letter is not true. Is that correct, sir?
That was an actual title when she worked at CRT. So what he's saying is.
Okay.
But what I'm, Jimenez, what I'm contesting is she wrote it as if she's an employee for the Department of Correction, which she is not. I clearly stated that she's an employee for a community resource team. There's a difference in that.
Yeah, and it's noted, I've noted it, that she works for one of the contracted providers.
Yep. What do you guys think? You guys think he's
Just
going
wanna
to
clear
get
up
denied
with respect
or
to
granted
that.
parole?
The letter does represent that she says that in the past, I was a forensic case manager. I think what her assertions are, given her training in these letters, speak for themselves. I understand that the hearing examiner has acknowledged the witnesses' points, Mr. Pearson's points, and I think we could take these with that representation for what they are purporting to say on behalf of my client. I would understand and believe that the hearing examiner has read both exhibits 1 and 2. Is that correct?
Correct.
Okay. Going forward to my comments as to probable cause,
Yeah.
is that the appropriate time now?
It is.
Okay, I have no comment.
The state,
Oh, I'm sorry.
we'll let the state go first. So at this time, the state will have the opportunity to make a short statement, call any witnesses, and testify with respect to the probable cause and the severity of the allegations. Officer Pearson, it's your chance to speak.
Man,
I'm
it
sorry,
looks-
can you repeat that again?
This is your opportunity to make a short statement, call any witnesses, or add additional testimony to the probable cause and the severity of the charges.
I don't have any additional witnesses to call. I just wanted to clarify the letter, which we just did. And I've only supervised Jimenez for a short period of time when he was transferred into my halfway house. But when we did find him, he was at Derrica James' residence in his boxers when he opened up the front door. So we have a reason to believe that he was residing there for an extended period of time. So that's about it at this time.
Okay, thank you. And now is the defense opportunity to respond.
Thank you. I have no comment as to probable cause as to charge 1. As to charge 2, the elements are not proof that someone was staying at someone's residence for a long period of time or any period of time. There has to be a proof that he permanently intended to change his residence. He was holding that as his permanent residence. I don't believe that there's evidence of that. As to charge 3, these are just reportings. There's no testing, just words of my client that he had used it. I don't know if that's sufficient under the probable cause standard. And I have no comment as to charge 4 regarding probable cause. As to the seriousness of the allegations, it's not required. It's not enough that these may be serious. The legislature and the regulations speak to it being sufficiently serious. So there has to be some degree of seriousness, more than just serious, to go forward with the next hearing. My client's been incarcerated for 30 days. He has not committed any new crimes. There's absolutely no allegations of his being violent. Charge 4 is just him diverting and doing different things when he was supposed to be on acid. He's been held for 30 days now. He clearly had an issue for about 9 days with using drugs. He could use drug treatment for that. And staying somewhere else. He didn't flee the jurisdiction. He may have been staying with his girlfriend, but I don't believe that's enough to go forward with a revocation of his parole. Rather, or if you do find it serious, I don't think his way sitting in jail any longer than 30 days is necessary or sufficiently serious enough to go forward with that. He only had 3 graduated interventions and sanctions, and they were all for the diversions from the approved pass. And this, I believe, may be his first violation of special parole. For those reasons, we'd ask that if you do find probable cause as to any of the charges, that you find it not sufficiently serious enough to warrant revocation or further incarceration. Thank you for your time and consideration.
Thank you.
You're welcome.
Can I say something towards that?
Yeah.
As for not having him, the attorney referenced of not having proof of being positive for the substances, but on the day that we did remand him, he did sign a voluntary admission stating that he used on those said days.
Just in response to that, even if he was using drugs, I think we all can take notice that drugs isn't going to, the jail is not going to solve someone's drug problem. Thank you.
So I'm just going to take a short second just to review all the new information provided and go over some of the prior stuff. And then I will. Officer Pearson, any last comments before I announce my findings?
No.
Counsel?
No.
Okay. I will now notify you of my findings of probable cause on charge 1, release directions, specifically GPS. I make a finding of probable cause based on the evidence and testimony presented in support of the alleged violation of parole. Based on Exhibit B, the parole conditions that were signed by the parolee on May 10th, 2024 and July 22nd, 2024, indicating his acknowledgement of the said conditions, which include GPS monitoring. Exhibit F, the parole violation report dated August 27th, 2024, which includes details related to the charge. Exhibit L, the GPS agreement that was signed by the parolee on July 24th, 2024, indicating his acknowledgement of the said agreement, which includes not removing the GPS device without permission from the parole officer. And Exhibit M, the Allied Universal Report, which shows a strap violation on August 11th, 2024 at 9:26 p.m. On charge number 2, residents, release directions, specifically residents. I make a finding of probable cause based on the evidence and testimony presented in support of the alleged violation of parole, specifically Exhibit B, the parole conditions that were signed by the parolee on May 10th, 2024 and July 22nd, 2024, indicating his acknowledgement of the said conditions, which include that the parolee was to live at a residence approved by parole. And Exhibit F, the parole violation report dated August 27, 2024, which includes details related to the charge. And said details include that the parolee left the halfway house without authorization, failed to return, and was located days later at his girlfriend's residence.
In boxers.
On charge number 3, the condition of bail laws, specifically drugs, I make a finding of probable cause based on the evidence presented in support of the alleged violation of parole, and this includes Exhibit B, the parole conditions that were signed by the parolee on May 10th, 2024 and July 22nd, 2024, indicating his acknowledgement of the said conditions, which include that the parolee was not to possess or use illegal drugs. Exhibit F, the parole violation report dated August 27th, 2024, which indicates that the parolee admitted to cocaine use.
I got something under my nails.
Oh, the voluntary admission form that is signed by the parolee on August 20th, 2024, indicating his admission to using cocaine. On charge number 4, the condition of additional conditions, specifically halfway house placement, I make a partial finding of probable cause, specifically with regards to part 1 to 4 of the charge, based on the evidence presented in support of the alleged violation of parole. Exhibit B, the parole conditions that were signed by the parolee on May 10th, 2024 and July 22nd, 2024, indicating his acknowledgement of the said condition, which includes a halfway house placement condition. Exhibit C, the halfway house agreement that was signed by the parolee on May 10th, 2024 and July 22nd, 2024, indicating his acknowledgement of the rules and expectations he was to follow while residing in the halfway house. Exhibit F, the parole violation report dated August 27, 2024, which includes additional details with regards to the various parts of the charge. Exhibit G, the residential discipline report dated June 4th, 2024, which includes information regarding the parole deviation, the parolee deviating from his approved community pass. Exhibit H, the misconduct dated June 4th, 2024, which was issued to and signed by the parolee as a result of the parole deviating from his community pass. Exhibit I, the incident report dated June 4th, 2024, which includes information regarding the parolee deviating from his approved community pass. And Exhibit K, the misconduct that was signed by the parolee on July 24th, 2024, which includes information regarding the parole officer locating pictures in the parolee's phone on days and times where he was issued halfway house community passes to be at other locations. The misconduct indicates that the parolee admitted to deviating from his community pass on 3 different dates and going to females' homes, as indicated in the pictures and videos parole located within the parolee's phone. And Exhibit P, a screenshot of the parolee's cell phone, which depicts him next to another woman, another shot of a video showing another woman, and pictures of a pool and selfie of the parolee. I do make a no finding in regards to Part 5 of the charge dated August 11, 2023, as the state failed to submit sufficient evidence to support that charge. As a result of the insufficient evidence, the elements were not met. The charge on the notice of parole violation that was issued to the parolee indicates an offense of August 11, 2023, and Mr. Jimenez was incarcerated on August 11, 2023. Furthermore, Mr. Jimenez terms of special parole did not begin until May 10th, 2024. Thus, this charge is factually impossible, or there's factual impossibilities for it. So those are my findings, and I find that the acts are serious enough to warrant revocation. And I've also determined that you should be detained while you await your revocation hearing. At the revocation hearing, myself or another hearing examiner will determine if you violated the conditions of your parole. And if so, the hearing examiner will make recommendations regarding whether your parole should be revoked or what, if any, sanctions should be imposed. Your revocation hearing will be scheduled within 60 business days from your return of custody, and you will receive a hearing disposition, which will have a tentative hearing date listed on it. And just note that all hearings are subject to change.
Okay, Mr. Jimenez, so what this means is that they found probable cause, they found that it was serious and that you should stay in jail. They have 60 days from the date of your remand, 60 business days to schedule the next hearing, okay? You will know before I do when the next hearing is going to be, okay, sir?
Okay.
I will contact you by telephone before then. And we will also hear from our social worker to make a mitigation report. Okay, sir? All right. Have a nice day. Tell me if you have any questions.
No.
Okay. Should Miss James call me? Do I have no permission to speak with her?
Definitely.
Okay. Thank you, sir.
Yeah, of course.
This concludes the preliminary hearing, and I'm now going off the record. All right. Thank you, Mr. Jimenez.
Yeah, thank you, bye.
Bye. Thanks, Officer Pearson.
You're welcome. Have a good day.
Take care, sir.
You too.
Right, you too, sir.
Next. He really was not interested in, but he knew what time it was. I mean, he got caught dead to rights. So, I mean, at that point, what is he gonna do? Say that he wasn't gonna do it anymore? I would have been doing the same thing, cleaning out the dirt or the grime out under my nails. What state? So let me see. Go back. Mandy writes, "Go sit back to your cell, son." Rita, what state? This is Connecticut. This is the state of Connecticut. Board of Parole hearings.
I'm gonna hang up.
All right. Well,
Thank you. Have a good day.
No problem. You too. Take it easy.
That's it.
Bye.
What? Come on now. I think they got another one going on. Let me double check. Give me a moment here. Let me check the other one. I gotta turn off my alarm over here. Just bear with me here. Give me a moment. Give me a momento. And I'm gonna turn off the screen for just a slight moment here while I go back to the other one. All right, we're gonna go to wake up. Yeah, it's my wake up. It's my time to wake up. Nah, they had another one going on right now. So let me just go to the other one right now. That one's kind of short though. I like it when they're a little bit when they have a little bit more individuals or incarcerated individuals. So let's see here.
Statute that simply is not enough for parents.
All right. Yeah, they got some other ones going on right now. I just gotta find let me see here. Give me a moment. All right, here we go.
Good morning, Public Defender Robert Famiglietti of the Parole Revocation Unit. Hello, Maria.
There we go.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony in today's hearing will be taken under oath. Ms. Gonzalez, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. First, I will read your rights.
What's
then
up with
we
her
will
eyes?
review the parole violation charges that the state your officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
I do.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to conduct cross-examine adverse witnesses. Do you understand these rights?
Yes, I do.
We now review the charges that the state your officer is bringing against you and the information underlying each charge. On charge 1, program participation, a no finding was made at the preliminary hearing held on July 31st, 2024, and will not be considered at today's hearing. Charge 2, obedience to the law. On July 12th, 2024, during your remand to custody by parole staff, you turned your head and spit directly at the face of the escorting parole officer. Based on your actions, you are in violation of Connecticut General Statute 53A 167C, assault on public safety, emergency, medical, public transport, or health care personnel. On July 12, 2024, during the remand to custody by parole staff, you were placed in the back of a caged parole vehicle for transport to a correctional facility for females. Immediately upon transport, you began to thrash and throw your body and head against the cage of the vehicle. You successfully manipulated your wrist restraints, causing you to no longer be restrained in an attempt to interfere with the transport to a correctional facility. Based on your actions, you are in violation of Connecticut General Statute 53A 167A, interfering with an officer. Charge 3, no consumption of alcoholic beverages. On July 1st, 2024, you consumed alcoholic beverages as evidenced by your voluntary admission of alcohol use. On July 10th, 2024, you consumed alcoholic beverages as evidenced by your voluntary admission of alcohol use. On July 12th, 2024, you consumed alcoholic beverages as evidenced by your voluntary admission of alcohol use. The state's exhibits were identified and marked at the preliminary hearing on July 31st, 2024. Counsel, did you receive this notice of parole violation parole violation report and other documents that were marked for identification purposes?
Yes, I am.
The defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today, we have no witnesses, and it is now the defense opportunity to present evidence or speak to any of the evidence submitted.
Yes, charge 2. The conduct did not rise to the level of arrest. It's clear she spat at the face. That's the allegation. She didn't spit. She was actually, that's one of the days where she had admitted to using alcohol in charge 3, July 12th. She, once upon learning that she was going to be brought to jail, she got sick. And she did not spit at anyone. She did nothing to get at the face of the officer. She was out of control in that she was getting sick as they were trying to take her into custody. And then the attempt to interfere, it's an attempt. She was brought to prison. She was transported to DOC. She did not flee. She did not run. So I don't believe it meets the preponderance standard. Thank you.
Charge 2, obedience to the law. I make a finding based on state's exhibits A, D, L, N, and N. On charge 3, no consumption of alcoholic beverages. I make a finding based on state's exhibits A, D, E, F, and I. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel?
Yes, my client's first violation of parole. She was out for approximately 3 years. I understand that her max date is 10/30/24, but she would like to be out prior to that max date. That is her wish. She, while incarcerated, was going to groups. She was in the methadone maintenance treatment program. She's single. She's 42 years of age. She receives her primary support from her sister, Vivian. She has 4 sons who reside with their father in Uncasville. She has her CNA certification. And she had been working for 1.5 years in the past as a housekeeper. She also worked as a CNA for compassionate care homemakers and was employed at the time of the remand and can return upon her release to that job. She worked in the SCRIP program in the past. She while at Silliman House, she was participating in weekly case management. She worked with a recovery coach at CCAR. She was in the MAT program in the form of methadone. She was also received intensive outpatient program and medication management at the Root Center. As I stated earlier, she was in the Second Chance Reentry Initiative program, SCRIP, and involved individual therapy, mental health group recovery, and every Wednesday employment services. While incarcerated, she works in the kitchen. She's medication compliant. She participates in a twice weekly mental health group. She participates in MAT monthly, as well as an MAT group. She would like to, once released, she would like to go to the CRT Scattered Site Housing Program. As she was working with them to obtain independent housing, she wishes to return to school, become an LPN, and she, as I stated, she'd work as a CNA when she's released at Compassionate Care Homemakers in Hartford. I don't think this violation is so serious as to require her to be held to the end of her sentence. She's not a violent person. She was getting sick at the time. She's been incarcerated now for 3 months almost. So we ask that you consider to release her sooner than her release date. Thank you for your time and consideration.
Counsel, regarding her housing, to
Yes.
be scattered site, in what location?
What location do you want to live in?
In Hartford?
Hartford, because that's where your job is, right?
Yes,
Thank you.
thank you.
You're welcome.
I recommend a revoke with no new parole date, which is an approximate 3.5 month sanction. In the event that the board chooses to lessen the recommended sanction, I recommend the following conditions: no consumption of alcohol, no contact with co-defendant Wayne Wells, Dawn Martin, and Samuel Vasquez, halfway house placement in the event that it's needed, and mental health evaluation. My findings and recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on October 3rd, 2024. The board may lessen my recommended sanction, let my recommended sanction stand. And if they let my recommendation stand, you'll go to your end of sentence. Okay, which is on October 30th, 2024.
That's the end of the hearing, okay? So the board's gonna meet on October 3rd. So call me on or after that day.
All
Okay,
right.
and I will let you know when you're going to be released, okay?
All right, thank you so much.
You're welcome, Maria. Good luck.
Okay.
I wish you the best of luck, okay?
All right, thank you.
Well,
So what happened? I missed it. I had to step away. I was getting my daughter ready for school. Any this live event? Oh, come on! I hate when they do that. So I'm gonna be so for anybody that's on TikTok, if you want to catch the video feed, we do have the video feed over on YouTube at Collect Call From. Fortunately my account's been restricted, and for now that's the way I'll be doing it, at least for today, and then while I figure some other things out, they will let her know. Hey, thank you, Starlight, and welcome. They will let her know after October 3rd. Okay, all right, cool. And then let's see over here.
Good morning.
Good morning, how you doing?
Good morning.
So we're not gonna get started for another 5 minutes. I have to wait till 9:30.
Okay.
9:30.
Yep, thank you.
All right, so I might be stepping out for a moment. I'm gonna go take my daughter to school, but I'll be back shortly. So you guys moderate yourselves, keep the comments nice and clean, if you will, and I'll be back shortly. Let me see here. I'm just going through the comments here. Thank you, M-Star Mad Max, for that information over there. Revisiting in a month, I heard. Man. Well, we got something to look. I guess we got something pending on October 3rd then. Man. Can you put it educational banner? Yeah. You know what? I went because they're gonna lift up the restrictions on my account tomorrow. I'll put the banner, but to be honest with you, I don't think it's gonna work. But I'll try it. We'll see what happens. All right. So tomorrow, I'll put the banner up. I'll get the feed going.
Good morning.
Good morning.
Your officer is going to be right with you.
Okay. Thank you. So yeah, I'll try that tomorrow. My access, the ban access gets lifted today at I think like about noon or so. So man, those 3-day bans, they're awful. James on TikTok, parole, strict parole. They got me on that strictness right now. So right now, just bear with me. Unfortunately, I don't have any control over the video feed on the on the YouTube side right now. It looks like they cut it for a moment or two. So once they begin, it should kick back in, and at least we should have I got about another 2 hours before I have to go head to work. So, we'll get through these live board of parole hearings in Connecticut. And all right, so I'm gonna step away now, and I'll be back shortly.
So can you please get like a direct movement? You don't figure out all these people waiting on you? You don't figure out all these people waiting on you?
We go so fast. We go so fast.
Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning J. Hotchkiss, 283-733. Today is Monday, September 23rd, 2024. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office and New Haven Correctional Center. Please state your full name and DOC inmate number for the record.
J.R. Hotchkiss, 283-733.
This is a public hearing. Public access to this hearing is available via video live stream. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Hotchkiss, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you.
Yes, yes.
First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney at this hearing. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing or proceed without?
Proceed without.
You have the right to receive written notice of the charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now review the charges that the state your parole officer is bringing against you and the information underlying each charge. On charge 1, GPS. Your GPS monitoring device died at 5:23 a.m. on May 14, 2024, and was not charged again until 10:21 p.m. on 5/17/24. This is a violation of your GPS agreement, which states, I am responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into an electrical outlet for at least 2 hours each day. Charge 2, drugs. You used cocaine and fentanyl daily from July 13th, 2024 to July 15th, 2024. Charge 3, halfway house placement. On April 16th, 2024, you were found to be in possession of 4 of your gabapentin pills during a pat search. You admitted that you had stolen them from the medication room and were keeping them on your person in an unauthorized container. This is a violation of your halfway house agreement, which states, I will take all prescribed medication as directed. On April 24th, 2024, you were observed by halfway house staff in an area of Hartford, not near where you signed out to be for your treatment programming. You admitted that you were apartment searching. This is a violation of your halfway house agreement, which states, I will only go to the locations indicated on an approved community pass unless changes have been authorized by staff. On April 26, 2024, you were due back to the halfway house from your treatment group at 4:45 p.m. You failed to return until 7 p.m. and admitted that you were downtown enjoying the outside air, since you have been incarcerated for 16 springs. This is a violation of your halfway house agreement, which states, I will only go to the locations indicated on an approved community pass unless changes have been authorized by staff, and I will return to the halfway house from community pass at my scheduled return time. If I'm unable to do so, I will call program staff to explain why I'm expected to be late and receive a new return time. On May 2nd, 2024, you signed out of the halfway house on a community pass to go to methadone and then to work. You admitted that you had deviated and gone to West Hartford to get a new cell phone before going to work. This is a violation of your halfway house agreement, which states, I will only go to locations indicated on an approved community pass unless changes have been authorized by staff. On May 15th, 2024, you signed out of the halfway house to go to your treatment group from 1:45 p.m. to 3:30 p.m. You failed to return or contact the halfway house, and your whereabouts in the community were unknown until your PO learned on May 17, 2024, that you had walked to the St. Francis Hospital emergency room at 8 p.m. on 5/15/24, reporting having auditory hallucinations. You were unaccountable in the community for approximately 4.5 hours. This is a violation of your halfway house agreement, which states, I will only go to locations indicated on an approved pass unless changes have been authorized by staff, and I will return to the halfway house from community pass at my scheduled return time. If I'm unable to do so, I will call program staff to explain why I'm expected to be late and to receive a new return time. On July 13th, 2024, you signed up at the halfway house on a community pass to the methadone clinic from 6:30 a.m. to 9:30 a.m. You failed to return or contact the halfway house, and your whereabouts in the community were unknown until your pro officer learned on July 15th, 2024, that you had arrived at St. Raphael's Hospital via ambulance around 3 p.m. that afternoon. You were unaccountable in the community for approximately 56.5 hours. This is a violation of your halfway house agreement, which states, I will only go to locations indicated on an approved community pass unless changes have been authorized by staff, and I will return to the halfway house from community pass at my scheduled return time. If I am unable to do so, I will call program staff to explain why I'm expected to be late and to receive a new return time. The state's exhibits were identified and marked at the preliminary hearing held on August 6, 2024. Mr. Hotchkiss, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes? It was
Yes.
the evidence packet. Okay.
Yes.
So today we have no witnesses, and it is now your opportunity to respond to the parole charges against you. However, remember that you may remain silent if you choose to do so. Do you wish to testify in regards to the charges?
No, I'm good.
On charge 1, GPS, I make a finding only on the GPS violation dated May 14, 2024, based on state's exhibits A, B, J, Q, R, and X. On charge 2, drugs, I make a finding based on state's exhibits A, B, R, and U. On charge 3, halfway house placement, I make a finding of state's exhibits based on state's exhibits A, F through I, K through P, and S through T. That concludes the fact-finding portion of this hearing. Before I make my recommendation, you will have an opportunity to speak to your background and history. So, Mr. Hotchkiss, what is your plan upon parole reinstatement? I know at your prelim hearing, you said you want to go to a New Haven halfway house. Is that still okay? And other than going to a New Haven halfway house, what else do you plan on doing?
I collect my SSI out there. I get my SSI, I get my MT, and I was on the list for housing. Because that's why I'm in the halfway. I didn't have no housing, so I'm just waiting for housing, or alternate place to live until I get housing. And that's why I'm gonna go to the halfway house for. wait for housing, because I qualify for housing. I get my SSI, my EBT, and I'm waiting for housing. And I'm gonna remain in that halfway house until I get housing. So under those circumstances, you know, doing the right thing, do what I gotta do, you know, this time I'm gonna be more focused and keep my head clear and, you know, make the right decisions and all that. Now, you know, I know this is a little, you know, this is like, I took it as like a wide eye opener, you know, like a lesson learner. And, you know, these past few months, I've just been, you know, been dwelling on my mind about what I should have been doing, what I shouldn't have been doing. And I know what I got to do, and I'll maintain my life, and nothing's worth it. You know, I'm not going to use drugs or nothing like that, or I want to stay clear-minded and all that. I have a very well equipped mind now on what I'm going to be doing. You know, I see things clearly for what they appear to be, and I know my wrongs, and I believe I made them right. You know, it's not like I was out there getting arrested or committing crimes or nothing like that. These are, you know, like violations, you know, that could have been, you know, that could be handled like this way, you know, and I just want to get back out because I know I have my eyes wide open and my mind is right. And I had to clear some things up, and now I believe I cleared them up in the right way, because I never want to live down the path like I once had, you know. It's just like, it cleared my conscience a little bit, you know, and I believe I'm ready.
And what is your relapse prevention plan?
I'm gonna, I'm on the methadone program, so I take my methadone. I'm gonna do my methadone. I'm gonna attend some groups, through the methadone. Through mental health services out there, because as soon as I go out, I start dealing with my mental health services and all that stuff. And just live like that, you know, keep on going to groups and maintain my life, you know, keep it well informed. And, you know, hopefully I'll be in a halfway house by, you know, whenever housing is ready for me, they'll let me know, and then, you know, I can go get my apartment. I got everything. I wrote down everything to apartment, how to decorate the apartment, everything, man. I can't wait, you know. I've been living like it. I've been living under roofs of, like, you know, authority for, you know, long. I can't wait to be by myself, and, you know, and really out there, you know. And this time it's like a really judgment. This is like a wide eye opener, you know. I can't wait to have my apartment and live on, and that's how I'm gonna do this time, you know. So take everything serious.
So your plan is to go to New Haven halfway house until you receive your own independent housing.
Yes.
Regarding income, you'll receive Social Security income, Social Security benefits, as well as like food stamps, EBT.
Yes.
And then you plan for relapse prevention. You're going to continue on methadone, attend groups, and also engage in mental health treatment.
Yes, absolutely.
Okay.
Yep.
Anything else?
No, that's it. Yep.
I recommend revoke and re-parole on November 15th, 2024, which is an approximate 4-month sanction. I recommend the following conditions: no contact with victims JL and the family of SH, the victim of your offense. Halfway house placement and mental health evaluation. My findings and recommendations will be forwarded to the board. You will receive the official written decision from the board, and your board review is scheduled on October 3rd. So on October 3rd, the board's going to take a look at your case. They can either lessen my recommendation, because my recommendation is November 15th, 2024. They can let my recommendation stand, or they can exceed what I recommended. If they do recommend a longer sanction, then a supplemental hearing would be held. And at that point, they will be giving you a written notice documenting the specific reasons why they might want to exceed my recommendation. And at that hearing, you would have an opportunity to respond to those specific reasons while in front of a panel of the board. So as it stands, my recommendation is November 15th, 2024. And on October 3rd, the board's going to make the final decision.
Okay.
Okay.
All right.
That is it. You're all set.
Okay. Thank you. I appreciate that. Thank you, guys. Yeah. Miss, is there any way I could change the New Haven halfway into Waterbury?
Yeah, that's fine. You want to do a Waterbury halfway house instead?
Yes. Yeah. Waterbury halfway house.
That's perfectly fine.
All right. Thank you. I appreciate that.
Thank you. No problem.
Yeah.
Good morning.
Morning.
We're not going to get started until 10. So whenever Mr. Gray arrives, that's fine. We just won't get started till 10 a.m.
All right, thank you.
Thank you.
All right, I'm back. I'm not sure what I missed, but I was reading some of the comments when I was over there, and you guys definitely had me. You guys definitely had me cracking up. All right, we still have another one, right? Did they say anything? Mirror, here we go. All right, I'm restarting up the TikTok stream because I came back to some major violations. Let's see, I'm gonna read some of the comments right here. Let me see. Afternoon, everyone. From Lynn, hey, welcome. Kay Easton, thank you, welcome also. Redbeard, welcome. Who else do we got in here? All right. Okay. Hopefully they're not over yet. I'm hoping they got some more individuals coming. Oh yeah, there's some. I see some movement in the background, so it looks like we might be having some more action soon. Oh, no wonder they restricted me. They were talking about I can't even say it on here because they might restrict me again. Let's see, what was the last message I left out at October 30th? Hey, thank you. Appreciate Leanners, thank you. Appreciate the like. Highly appreciate it. And let me see here. So the next individual obviously hasn't walked in. What do you guys think? Do you guys think the next person's going to be found suitable for parole? Or are they going to be getting denied? Has anybody got found suitable yet? I know that young lady with the weird eyes, she got postponed till October 30th. Let me see. Crazy Grandma. Oh, thank you. All right. So the last dude he got found suitable. Well, I'm not sure if it was the last guy, but Redberry, thank you for that motivation right there. You took to get the thumbs up. Bro was tore up worse than the last one. He's saying what he thinks they want to hear. Redbeard, but he's ready to get out and get high. The other comment, I can't read that one because it's mentioning a certain substance that helps people get off other substances. So I'm not going to read that one. Mad Max wrote facts. He can't wait till he gets that SSI. He's been stacking while he's locked up. Oh man, I shouldn't even be laughing at this stuff. But you know, what can you do? Can't work if it's used the way it's prescribed, yeah. But people start abusing it, so 90s red beer, they say sober treatment and use of a certain prescribed medication as an option that's not treatment, just allows the government to capitalize on your addiction. Okay, Easton, what were the original charges? And Mad Max put weird eyes laughing out loud. Oh man, we're on the same boat right there, Mad Max. He said, I missed it because I'm taking the kids to school, but I'm sure rugs were related in some way. You can't talk about, I don't know, you know what, I'm not even sure, because you know everything's so heavily restricted nowadays that I don't even know what is allowable and what's not. But you know, I'm running a double stream, so if I say that, you know, on YouTube, it might affect my stream on TikTok. So you know, just to avoid any issues, you know, I just play it safe, and we'll do it like that. Let me see. Crazy Grandma wrote on TikTok, November 15, I believe that too. All right. So right now, man, what are they on lunch break right now or what? It's too early to be on a lunch break. They just started about it's only 2 hours in. Oh, they needed their 15-minute break. That's what it must be. Yeah, you better believe I was working. I'm gonna be taking my 15-minute breaks. That's mandatory. So let me see. So today I'm gonna probably be streaming for about another an hour and a half, and if these hearings are longer, then I'll just let it run on YouTube, and then I'll just have my wife cut it once it's over. Hey JP, Stitch, hello everyone. Hey, welcome. Thank you, highly appreciate it. You know, it's nice, to get some traction over on YouTube with these Board of Parole hearings. 90s Redbeard, what up, JP? Manny, he never mentioned getting to work. Hey, break already. I hear some noise, so that's hopefully that's a good sign right there. A native girl. Hey, thank you. Highly appreciate it. Appreciate you sharing the live. You know, you guys are the ones that are helping me out with YouTube and the TikTok. So highly appreciate it. And I definitely don't take you guys for granted. I appreciate you once again. JP wrote, not much, are you? Hey, I can't complain, other than besides, having to go to work for the next few hours. And I mean, everything's good. Joseph, where are we at this morning for the hearing? So today, we're in Connecticut. We're in the second half of the hearing. We finished one parole agents hearings, and we're on the second one now. I double checked Utah. In Utah, it looked like they only had one hearing available, and when I checked it earlier, it hadn't started yet. So Utah probably won't be going down today, and I didn't see any other hearings in any other states. I know for tomorrow it's gonna be definitely be pretty interesting. We have some hearings. Let me see. I got some notes right here, and let me see these notes here for tomorrow. So for tomorrow, let me see. We got some hearings in tomorrow's the 24th. Oh, we're gonna have Minnesota. We've never done Minnesota before, so I'm excited for Minnesota. We also have some hearings going on in Vermont, so we're gonna be doing Minnesota, Vermont, and Iowa. I'm assuming, Iowa. I think they have some board hearings. Man, tomorrow's gonna be a fun-packed day, so I don't even know which one I should I start off from Vermont or Minnesota. I gotta double check. I'm not even sure what time zone Minnesota's in right now, so I'm not sure if it's Eastern or Central. So I gotta go ahead and double check that. And tomorrow should be an interesting day. All right. Oh, all right. We got the next individual walking in. I think the stream might be a little bit
Good
delayed.
morning, Mr. Gray. We'll get started in about 5 minutes.
5 minutes?
Okay.
What the what? Come on now, you guys are over here. I'm from Minnesota, so that's gonna be cool. Yeah, I've never seen a Minnesota one before. Is this available on the internet in the States? That is correct. Yes, it's all this is public information. There's I think six states that they're really easy. You don't even have to sign up or anything. You just click on the links and it'll get you started. Yesterday I was I was trying to make some more connections, so there possibly, hopefully, I'm able to bring some new states. JP, it's 10. Okay, so you're 2 hours ahead of us. Where it's on Pacific Standard Time, so it's 8:12 over here. Is this, yeah? So yeah, K Easton, yeah, K Easton, yeah. This is all available. It's public information. Let me see right here. JP 100. Good deal, man. Good to hear. Joseph. All right, I read that message already. And then JP, got any in South Dakota? No, I was actually checking yesterday. I was checking North Dakota. You know what? I was checking the whole country, all 50 states and all major territories, and I couldn't find anything new. So, but if something does come up, you definitely you guys will be seeing it on either YouTube or TikTok. Snow, hey, how's it going? Good morning. Minnesota Central. Hey, thank you for that. And then Native Girl, say prayers. I'm going to court. Whoa, hey, good luck. You're gonna go today? Oh, we got my boy Danny Boy 01. Bueno. That's right. Hey, gracias. Highly appreciated. Snow, tap. Yo. Yup. So they should be starting here in the next few minutes. They said about 5 minutes, about a minute ago. So we probably got about 4 more. What do you guys think? This next gentleman that's coming up for this parole hearing, do you guys feel like he's going to be found suitable? Let me see. Wow. K Easton writes, wow, that's crazy. I'm from NZ, New Zealand, right? It's all private here. It's 3:13 a.m. Tuesday here. You're living in the future. That's right. Yeah, you know what? I before I started this YouTube channel and TikTok channel, I had looked around, and it seems like everywhere but the United States, it's all this information is confidential. Like in the U.S., you could look up inmates, based on the state they're in, just by typing in a name, or you could look up court cases, parole hearings. A lot of that stuff is public information. So anybody wants to look it up, they can. So I'm pretty sure people are tripping out on that. Damn. Let me see. Snow, is this MN? No, this is this hearing we're at right now. This is gonna be Connecticut. We're in Connecticut today. Oh, you're doing my state today. You're in Connecticut, Snow? Minnesota's gonna be tomorrow. Okay, thank you, sir. Nope. Utah. So I checked Utah today. Utah, they only had one hearing, and when I checked it earlier on, it hadn't started. So I'm not sure if it's gonna be taking place a little bit later. And I just looked at my computer screen, my other computer screen, and that one hasn't started yet. So who knows when they're gonna start that one? Hey, Kilo, welcome. Buenos dias. Gracias. Welcome back, Kilo. And for those of you that are on TikTok that are visual and that you guys want to see the individuals on these Board of Parole hearings, I'm also running a stream on YouTube at Collect Call From, and where you can see the visuals. And as an added bonus, if because I know the TikTok conversation is a little bit let's see what word can I use, on fire, if one can say. I added the TikTok chat on the screen of the YouTube stream, so like that, if any funny comments are coming in and whatnot, you won't be missing out. And man, we gotta go ahead and get one of these going, just so get the blood flowing, wake everybody up, and let them know it's time to get up. We got Jack. Hey, Jack, buenos dias. Hey, thank you for that comment. Let me see. Did we get KC _? Hey, we got it. Nice, man. Studio's looking firme. Hey, gracias. Highly appreciated. You see that brown jumpsuit right there? My friend right there, Danny, that's in the chat. If you scroll up a little bit, he hooked me up with that right there. Highly appreciated. Adding a little bit more to the background and whatnot. Good morning, KC _fan. And we're just waiting for this.
Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Beanie Gray Jr. 596. Today is Monday, September 23rd, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Corrigan Correctional Institution. Please state your full name and DOC inmate number for the record.
My name is Benny, Bennie, Gray, Gray, Jr., and my inmate number is 259596.
This is a public hearing. Public access to this hearing is available via video live stream. This is a preliminary hearing which has three purposes under Connecticut law: to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversary proceeding. Anything that you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Gray, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, I do.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state, your officer, is bringing against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, I do not.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney and may hire your own attorney. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing or proceed without counsel?
Honestly, I wanted to waive this hearing.
Would you like to waive it today?
Yes, ma'am.
Okay, so I'm just going to read your rights. And then at this point, after I read your rights, and if you still wish to waive, we can move forward. Okay. So you have the right to receive written notice of the charges of violation. You have the right to review the evidence against you before this hearing, and you have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand that you're waiving these? Do you understand these rights first? Do you understand your rights?
Yes, I do.
Okay. And do you understand that you're waiving your right to have a preliminary hearing at this time?
And as far as the charges against me, yes, I guess the pending charges in court or whatever. Yes. One of my issues is with the I think it's count 3 with me not allowed to drive. I don't understand how do I fight that when I presented basically my driver's license and my records and showed that I have nothing against me, and my parole officer said go ahead. Now I'm being charged for driving. So I really don't understand that one. That's the one that really that's the one that that I would like to challenge. But how do I challenge that when there's no process for me to sign and say, okay, you've given me permission to drive. Now I go forward. I presented all the documents showing that I have nothing against me as far as driving. I have nothing on my, as far as my driver's, but I have, and she's looked at him and said, oh, I don't mind. Go ahead. Now I'm being charged with driving without permission. I don't understand that.
Okay, so this is the hearing for your prelim, right? So if you wanted to present evidence so you can provide evidence to state these are your reasons why you don't necessarily agree with there's probable cause that you violated that charge for operation of a motor vehicle without the express permission of your parole officer. However, if you're waiving your right at your preliminary hearing, your revocation hearing would then be scheduled upon the disposition of your pending charges, at which time you can also provide evidence at that time. So if you want to move forward today with your prelim, we can do that. Or if you want to provide evidence on your behalf or make a statement regarding that you don't agree with that charge, that's up to you. But if you're waiving your right today not to move forward, then we're not going to discuss the charges because you're waiving your right to this hearing.
Okay, so can I ask you this? Is it possible, say for instance, because I have 3 counts, right? 3 charges. Is it possible to waive my right or to, I guess, say probable cause or a waiver or whatever for the first 2 counts, because I have pending charges. Until that's resolved, we assume probable cause. But to the 3rd charge, there's no way I can challenge that, or I have to waive everything. How would it go?
Yeah, you're waiving your whole hearing today. You would be waiving everything, that we're not moving forward, or you're waiving this hearing, and then you would be heard at the revocation hearing. So you cannot say, oh, I want to just waive 2 charges versus in the not 1. You're waiving all of them. You're waiving the right to have this hearing to discuss the charges, all 3 charges.
All right, so well, I don't want to waive it, and I'll just deal with, if you find probable cause for the first 2, which I believe that may be the case because I haven't resolved those issues. But the 3rd one, I really have an issue, and I'd rather, put something on the record in regards to that.
Okay, so we want to move forward with today's hearing.
Yes, ma'am.
Okay. We now will review the charges that the state youth officers bring against you and the information underlying each charge. So on charge 1, obedience to the law, on September 5th, 2024, you were pulled over driving a vehicle in Norwich. Subsequently, your fanny pack was searched and officers found 23.2 grams of a white rock-like substance, crack cocaine, and glass-lined baggies containing 3.3 grams of purple powder substance fentanyl. In addition, in the vehicle was $2,420 in U.S. currency located in the central console. $42 located in your wallet, $31 in U.S. currency was located within the vehicle. Glass-lined baggies containing 208 grams of a purple powder substance fentanyl. You were charged with 2 counts of possession of controlled substance and 2 counts of possession with intent to sell. You were arraigned at GA 21 on September 5th, 2024, and probable cause was found. You were given a bond of $50,000 with the next court date of October 3rd, 2024. Charge 2, drugs. On September 5th, 2024, you were pulled over driving a vehicle in Norwich. Subsequently, your fanny pack was searched.
Fanny
and
pack.
Officers found 23.2 grams of a white rock-like substance, crack cocaine, and glass-lined baggies containing 3.3 grams of purple powder substance fentanyl. In addition, glass-lined baggies containing 208 grams of a purple powder substance fentanyl was also found within the vehicle you were operating. You were charged with 2 counts of possession of a controlled substance and 2 counts of possession with intent to sell. You were arraigned at GA 21 on September 5th, 2024, and probable cause was found. You were given a bond of $50,000 with the next court date of October 3rd, 2024. On charge 3, operation of a motor vehicle. On September 5th, 2024, you were observed operating a white Nissan Altima in the city of Norwich. You were subsequently pulled over by Norwich Police Department for not using a turn signal. Subsequently, you were arrested for possession of narcotics and possession of narcotics with intent to sell. You did not have permission from your parole officer to operate a motor vehicle. The state has filed the following exhibits. Exhibit A, signed statement of an understanding and agreement of conditions of parole. Exhibit B, remand to custody order. Exhibit C, violation notice of parole. Exhibit D, parole violation report. Exhibit E, Board of Pardons and Parole Revocation Summary. Exhibit F, Board of Pardons and Parole Disposition Summary. And Exhibit G, Police Report of City of Norwich. Now, Mr. Gray, did you receive the notice of parole violation report, and the other documents that I just marked for identification purposes?
I just received, I believe, Friday. Yes, I did.
So today we have no witnesses, and it's now your opportunity to respond to the parole violation charges against you. However, remember that you may remain silent if you choose to do so. Would you like to respond to the charges at this time?
As to charge 1 and charge 2, I'll remain silent at this time.
Oh, before we proceed, when I was reading your rights, you didn't indicate if you wanted to proceed without an attorney or not.
Yeah, I wanted to proceed without an attorney.
Okay, I just wanted to put that on record. Okay.
Yes,
So charge 1 and charge 2, you wish to remain silent.
Yes, I do, ma'am.
Okay, regarding charge 3.
Regarding charge 3, I just want to put on the record that I like I said, I met with my parole officer, and as you see the written that you have to sign, as far as the conditions go, I was explaining all the conditions, mental health, go for the drug screening. I did everything that she told me to do, and I asked about the condition, as I did at the revocation hearing, about co-defendants, because I believe they have down that I have an aggregate charge of a large is a misdemeanor count, and I've like I said, I've made an argument because I'm like, I have no aggregate charge. I was given time served on a misdemeanor count, so that that charge shouldn't even appear. It's not an aggregate. Aggregate is when you have two consecutive sentences that run together and they merge into one sentence. That would make that old charge active. My case, that case was, I was given time served on that day. And like I said, I don't understand why they didn't look at the minimus, but they told me I couldn't be near my wife. That was my issue on there. One of the people on there, Amanda, they have as Amanda Barton, but her real name is Amanda Gray, and that is my wife. So I talked to my parole officer about that. She said, I'm not gonna have any issues as far as that goes. You can be next to her. And then we addressed the driving situation. And under the driving situation, she asked if I had valid license. I showed her my valid license. I have nothing pending in the state of Connecticut that will prevent me from doing that. Part of my job, I got to drive. I do circles around in a security truck. So I expressly showed her my identification and explained that to her. And she said, I have no problems with that. You'll see me 2 more times, then you'll be moved to once every 3 months because I'm part of the violent task force and you're on my caseload and you shouldn't be on my caseload. Those were the only words I ever had with her. I never had anything where she said I couldn't drive if need be, because if that's the case, I wouldn't have been able to work where I'm working at. So that's pretty much it.
Well, he's definitely speaking up for himself. You know, a lot of times,
On charge 1, obedience to law, I make a finding of probable cause based on State's Exhibits A, D, and G. On charge 2, drugs, I make a finding of probable cause based on State's Exhibits A, D, and G. On charge 3, operation of a motor vehicle, I make a finding of probable cause based on State's Exhibits A, D, and G. I find that acts are serious to warrant revocation, and I have also determined that you should be detained while you wait your revocation hearing. So your revocation hearing won't be scheduled until the disposition of your charges.
Correct.
Okay, so that does conclude the preliminary hearing. And I will make a note on record everything you just testified today.
Okay.
All right.
Thank you.
Thank you. You're all set.
Damn. All right, man. Hey, sometimes these hearings go kind of quickly. If you're not really paying attention, you're gonna miss what's happening. I look away for a moment and whoa, easy there.
Yeah.
Oh, that's sticking your hands in your pants. Gotta keep that down to a minimum. There might be kids watching. All right, is it that? All right. So hopefully we still. Let me check how much more time that we got on. Okay, so we still got some time on this hearing here, so let me see here. All right, so we just have to wait for it to start up again, and once it does, then it'll come back on the screen. Wait a moment.
Of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be held to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Giddings, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you.
Hey, who's laughing?
First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
I got a question about them pants.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney.
Hey, are
you
those
have the
kitchen?
right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
What's up with them pants? Do you guys think he works in the kitchen? Are those culinary pants?
We now will review the charges that the state your officer is bringing against you and the information underlying each charge. Charge 1, program participation. On April 16th, 2024, you were instructed in person by this parole officer at the Open Hearth Halfway House that you were required to attend an intake at CRT for program participation in IOP on April 23rd, 2024. You filled out your pass with this PO and were instructed to turn your pass in to your case manager and attend. You turned your pass in, but then subsequently failed to attend this appointment. Based on your behavior, this places you in clear and direct violation of your signed parole conditions, specifically under release direction, program participation, as you were made aware that you needed to attend this intake. You were aware of your intake appointment date, time, and location as discussed with you by this PO, and you failed to attend your intake as scheduled. On May 1st, 2024, you completed your intake for IOP at CRT. You were made aware that you needed to attend 15 sessions and were provided the dates and times to attend of Monday, Tuesday, and Wednesday from 9 a.m. to noon. You then sporadically attended your sessions, therefore giving reasonable belief you were aware of your days, times, and locations you were to attend as you had attended on other assigned dates. On June 26, 2024, CRT reported you failed to report to IOP on June 5th, June 10th, June 11th, June 12th, June 18th, and again on June 25th, 2024. Based on your behaviors, this places you in clear and direct violation of your signed parole conditions, specifically under release direction, program participation, as you were made aware that you needed to attend IOP. You were aware of your session days, times, and location, and you failed to attend your IOP sessions as scheduled. On charge 2, absconder, that on June 25th, 2024, you exited your only parole and community services approved residence, the Open Hearth Halfway House, located at 150 Charter Oak Avenue in Hartford, Connecticut, at 8 a.m. on a community pass to attend IOP at CRT, and had a pass return time of 1:30 p.m. You failed to report back to the halfway house at your scheduled return time. This PO was able to make phone contact with you and gave you verbal direction to return, and you stated you would, but failed to do so. This PO made multiple attempts to locate you directly and via other sources on June 25th, June 26th, June 27th, June 28th, June 29th, July 1st, July 3rd, July 8th, July 10th, and July 11th, as well as in addition to an attempt to physically locate you in the community on July 10th in the town of Enfield. You failed to report back to the halfway house. You failed to contact your parole officer after June 25th, 2024, and you failed to turn yourself in. Your actions and lack of communication clearly demonstrate your intent to evade your parole supervision. Your whereabouts in the community are unknown at this time. Charge 3, drugs. On or about March 27th, 2024, you used cocaine and fentanyl. This behavior places you in clear and direct violation of your signed parole conditions, specifically under obey all laws where it states, I will not use or have in my possession or control any illegal drug, narcotic, or drug paraphernalia. On April 13th, 2024, you used fentanyl. This behavior places you in clear and direct violation of your signed parole conditions, specifically under obey all laws where it states, I will not use or have in my possession or control any illegal drug, narcotic, or drug paraphernalia. On April 16th, 2024, parole conducted a pat and pocket search of your person after you admitted to using fentanyl. Located in your right pants pocket was a gray big pen with both ends missing and Brillo stuffed inside. Through training and knowledge, this is recognized as a way to ingest illegal substances. This behavior places you in clear and direct violation of your signed parole conditions, specifically under obey all laws where it states, I will not use or have in my possession or control any illegal drug, narcotic, or drug paraphernalia. On June 25th, 2024, Halfway House staff conducted a pat and pocket search of your person and belongings after you returned from work. Upon searching your backpack, staff subsequently located a pipe with a white residue on it. The pipe was rolled in toilet paper. Through training and knowledge, this is recognized as a way to ingest illegal substances. This behavior places you in clear and direct violation of your signed parole conditions, specifically under obey all laws where it states, I will not use or have in my possession or control any illegal drug, narcotic, or drug paraphernalia. Charge 4, halfway house placement. On June 24th, 2024, you were issued a work pass to go to Sardelli Produce and had a return time of 2 a.m. on June 25th, 2024. You returned late at 2:25 a.m. Upon review of your timesheet from Sardelli Produce, you clocked out of work on June 24th, 2024 at 10:34 p.m., therefore making you unaccountable in the community for approximately 4 hours. This places you in clear and direct violation of your signed halfway house agreement, specifically where it states, I will only go to locations indicated on an approved community pass unless changes have been authorized by staff. You do not have permission from anyone to be anywhere other than Sardelli Produce.
Damn.
The state has filed the following exhibits. Exhibit A, PCS conditions. Exhibit B, halfway house agreement. Exhibit C, the open hearth incident report for a positive drug screen. Exhibit D, red wool toxology report. Exhibit E, offender misconduct. Exhibit F, voluntary admission. Exhibit G, offender misconduct. Exhibit H, offender misconduct. Exhibit I, contraband pictures ×2 for contraband located on his person. Exhibit J, email from clinician Alora Salamacha, SCRT. Exhibit K, offender misconduct. Exhibit L, email thread for confirmation of IOP days and times. Exhibit M, Hartford Healthcare discharge summary for hospital stay. Exhibit N, open hearth incident report. Exhibit O, open hearth incident report. Exhibit P, open hearth incident report. Exhibit Q, contraband pictures ×2. Exhibit R, letter from CRT clinician Tony Ann Malcolm. Exhibit S, letter from Krista Clark Sardelli Produce. Exhibit T, time card report from Sardelli Produce. Exhibit U, video evidence. Exhibit V, Troop H, police report. Exhibit W, remand to custody. Exhibit X, notice of parole violation. And Exhibit Y, parole violation report.
Hey, you're right,
The
Mad
state
Max.
filed an addendum to Exhibit Y, which states on September 12, 2024, the charge of use of drug paraphernalia was nollied under docket ending in 844. Counsel, did you receive the notice of parole violation, parole violation report, and the other documents that were marked for identification purposes?
Yes.
Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today, we have no witnesses, and it is now the defense opportunity to present evidence and speak to any of the evidence submitted.
Thank you. In regards to charge 1, the program participation, just looking at the first portion of that charge, I would just note that that appointment was rescheduled to May 1st of 24, and it was completed on that date. The intake was completed on that date. In regards to the second portion, which begins on May 1st of 24, I would just note that my client successfully completed 6 of the 15 sessions. Looking at Exhibit R, it does not indicate that my client at any point in time was unsuccessfully discharged from that programming. And in fact, he was still in that programming, technically up until the time of his remand, having never been discharged. There is a notation that he was in the hospital from May 16th of 24 to May 24th of 24. And my client does tell me that that was for a medication change. He went from being on medication-assisted treatment using methadone to medication-assisted using Suboxone, as well as issues with his heart. But he did have a medication change during that time period. And again, he was never unsuccessfully discharged from that programming. In regards to charge 2 under absconder, my client indicates that he was at CRT, that he had a conversation with his parole officer, and that she indicated to him that if he did not return back to her office within 10 minutes, that she was going to violate him. And based on that, he knew he couldn't get back in that period of time. And so he admittedly made a bad decision. In regards to charge 2 under Obeah laws, in regards to under Obeah laws charge 3 drugs, addressing the April 16th, 24 paragraph, as well as the June 25th, 24 paragraph, both of those paragraphs are alleging that my client was in possession of drug paraphernalia. And I would just point out that per the drug paraphernalia statute, which is 21A 267A, no person shall use or possess with the intent to use drug paraphernalia. And I'm just going to speak specifically to the section that's relevant. As defined in subsection 20 of 21A 240, and it specifically indicates to ingest, inhale, or otherwise introduce into the human body any controlled substance as defined in 21A-240 other than cannabis. And if you look specifically at both of these paragraphs, there's no indication whatsoever as to what the substance my client is alleged to have been trying to ingest into his body. And the statute requires that there be a substance, a controlled substance, other than cannabis, which is marijuana, that he was attempting to try to ingest into his body using what they're alleging the paraphernalia to be. There's nothing alleged whatsoever in the paragraph April 16th of 24. In the paragraph June 25th of 24, there's an indication of a white substance. However, there's no indication as to what that substance is purporting to be. There's no drug test as to that substance. There's no even allegation as to what they're claiming the substance to be. They're just indicating white substance. So per the statute, that simply is not enough for paraphernalia. And I would point out that the June 25th conduct was the subject of an arrest for drug paraphernalia, which obviously was nollied in court and did not meet that burden in court as to what in fact my client was attempting to ingest with that paraphernalia. So we would submit on both of those paragraphs if there's insufficient evidence to support the charge. In regards to charge 4 under halfway house placement, my client simply tells me that he went out for his break and that when he returned to work, he neglected to punch back in, that he was in fact at work during that entire time period. Nothing further as to the charges.
Let's take a moment before I announce my findings.
What do you guys think? Do you guys think he's going to be found suitable? Does he have?
I say one thing.
Hold up.
In regards to what?
The CRT, I had actually only had 6 classes left. I had completed 9 out of the 15 classes. I only had 5 or 6 classes left before they were supposed to discharge me.
Yeah, I know.
And I was going to be out of the halfway house. She said as soon as I finished CRT, she was going to put me in for a parole bed. So I had 5, like a week left of the classes.
So I understand that. And, yes, and if you heard, I just noted that they never unsuccessfully discharged you, which would indicate that you were still in the programming. Yes.
Thank you. Thank you.
Hey, for those of you that are on TikTok, if you guys are a bit frustrated as far as the stream getting cut, I suggest for you guys to jump around on YouTube at Collect Call From. And it runs pretty smooth over there. I don't get the same restrictions as I do over here on TikTok, if you will. But so what do you guys think? Do you guys think he's gonna get? Because nobody's been found suitable to get parole today, right? Everybody's been getting denied. Mad Max wrote he sounds like a convict from the East Coast, laughing out loud.
On charge 1, program participation, I make a finding based on State's Exhibits A, G, J, K, L, P, R, and Y. On charge 2, abstander, I make a finding based on State's Exhibits A, B, P, R, S, and Y. On charge 3, drugs, I make a finding based on the State's Exhibits A, C through G, H, N, V, U, and Y.
Damn.
On charge 4, halfway house placement, I make a finding based on State's Exhibits A, B, N, O, S, T, and Y. This concludes the fact-finding portion of this hearing. Before I make my recommendation, you have opportunity to speak to your background and history. The purpose of this part of revocation is to help determine what outcome I recommend.
I'm sorry. In regards to those paragraphs addressing the paraphernalia, can I just indicate what exhibits you were relying on?
All of them, the whole alphabet.
You may repeat the exhibits?
Yeah.
Okay.
Yeah, I just want to.
So that's under
charge 3.
Charge 3. Yep. Yeah. So A, C through G, H, N, V, U, and Y.
The only thing she forgot was X, Y, and Z.
Can I just ask them how any of those exhibits address specifically paraphernalia? I'm just confused because the paraphernalia statute requires that there be a controlled substance, but there's no allegation of a controlled substance.
So under drugs,
yeah,
right, it says, I looked at the. I will not have in my possession or control any illegal drug, narcotic, or drug paraphernalia.
Right.
But so the statute you read is that it's the actual charge of
Right,
possession of,
but the definition of paraphernalia.
right? So then means any object or material listed in subdivision 20 of section 21A 240.
Right.
So what that provided was the actual, how I read that, was that that's the actual statute for the definition of like that law, for the law. For drug paraphernalia, under our stat for this, is stating any object or material.
Right, but that's also referencing 21A.240, correct?
240. Mm-hmm.
Which is the definition section, right?
So, because what that
it just means that anything could be paraphernalia, right?
So what's
unless there's an allegation that it's being used specifically, what is paraphernalia, right? Unless it's being used to ingest an illegal and controlled substance, then how is it paraphernalia? So in this particular case, they're saying a big pen is paraphernalia, is drug paraphernalia.
With Brillo pads.
Right, so why is it drug paraphernalia, right? Because it's obviously being used, or the allegation is that it's being used to ingest an illegal substance or controlled substance, but they're not alleging a controlled substance.
But alleging that he had in possession, which he's not supposed to have in possession of
a big pen
of drug paraphernalia.
Okay, I just I find it to be a reach, but I respect your decision. Thank you.
Okay, so is your opportunity to speak to?
Yes, the background and history. Yes, thank you.
All right. And so for those of you that are on TikTok,
Mr. Giddings is 36 years of age. He's single, though he's in a committed relationship. And he does have a stepdaughter that he raises with his significant other, who's 14 years of age. He completed his high school diploma at Corrigan in 2008. He does have a strong support system in the community, and both his mother, father, as well as a sister. While he was in the community for approximately 4 months prior to the alleged absconding. And during that time period that he was in the community, he was able to hold employment working at Sardilli's in Hartford, as well as at Seal Pro Incorporated in Windsor, which is a company that's owned by one of his friends. He was attending the programming, as we've already talked about, at CRT. And as he self-reported, he completed 9 of the 15 sessions. And during that time period that he was in that treatment, he was receiving medication-assisted treatment in the form of methadone, and that did change to medication-assisted treatment in the form of Suboxone. He was also receiving treatment at the Root Center in Hartford, where he completed an IOP on March 26th of 24. He also was participating in 12-step meetings while he was at Open Hearth Halfway House. He's indicating, actually, I'll just step back a minute. While he's been in the Department of Corrections custody, he's again receiving medication-assisted treatment in the form of methadone. He participates in treatment groups once monthly, as well as holding employment working in the kitchen. He indicates that upon his reinstatement to parole, he would like to go to a halfway house in the Hartford area. He indicates he can return to his employment at Sardilli's, as well as his employment at Seal Pro in Windsor. He would like to further his education by way of enrolling in Tractor Trailer Training School to obtain his CDL. He'd like to reestablish his treatment services at CRT and continue with medication-assisted treatment while in the community. We are asking that you take all these things into consideration. He's on parole, I believe, until February 11th of 2026. He's been remanded to custody now since July 31st of 24. So taking all of these things into consideration, we would be asking that he be re-paroled at the next available date. Thank you.
Hey, did you guys hear, or your ladies hear, that he's single? Check it out. He might be taking applications right there. Definitely got a winner. What do you guys think? Is he going to be found suitable?
Revoke and re-parole on March 31st, 2025, which is an approximate 8-month sanction. Well, this is, the reason for that is this is Mr. Giddings' 3rd violation, in addition to 2 TOPS placements. We have him for using and not successfully completing treatment. I recommend the following conditions: no consumption of alcohol, general no contact with Taylor Williams without the express permission of your parole officer, no contact with Liberty Bank.
No contact with whom? No contact with Taylor Williams.
Yeah, without the express permission of your parole officer.
Why is that? That's my significant other. Why can't I have contact with my wife?
Given that
I thought he was single.
She's not a victim. She's not in any of my crimes. She
So
has
as long
nothing to do
as,
with any of this.
so as long as your parole officer sees fit, and again, these are my recommended conditions, the board could change that. But you can have contact with as long as the parole officer sees fit.
Can I just ask, was that a continuing condition? Was that previously his condition?
No.
You're adding that as a
Yes,
condition?
is added.
But
Yeah,
why?
based off of the fact that she's noted in the PVR as being arrested at your employment.
Yeah, because she went to do me a favor to pick up my paycheck, and my parole officer my parole officer lied in 90% of my report that she gave to you. Half of that shit is lies. And I'll swear on the Bible to that. She admitted to it and here she came to apologize to me. Didn't even come to see me, and she still came and saw me and apologized for it and said that was her pride that caused this shit. And that's what she did nothing but better my life. And now you're trying to. I just don't want to. I feel like I'm getting railroaded right now.
Railroaded.
Again,
I did everything parole asked of me. And the only reason I left
the
is
board
because
has the final decision. The board has the final decision. I will make note that you are not in
there.
agreement with this condition.
Yeah.
Is this done? Can I go?
Yeah.
Can I get to go? Thank you.
Unless he had a prior, please sit down. Unless he had a prior domestic violence incident or something where she was a protected party in a case, yeah, we would just object to that. I don't see how it would be relevant that her picking up his paycheck and having an argument with somebody at his place of employment would have anything to do with his relationship with her and how he would conduct himself in the community, continuing to have a relationship with her. He's had a long-term relationship with her. He is a father to her child, the only father that her child really knows. And that would obviously be a significant loss for him, as well as that child, to have him not be able to be part of their lives.
So again, this is not final. These are my recommendations. I will make a note for the board that you guys are opposing this condition. And on October 3rd is the hearing. Oh, so also I didn't finish my condition. So no contact with Taylor Williams without the express permission of your parole officer. No contact with Liberty Bank located in Handham and Oxford, Connecticut. Halfway house placement in the event that it is needed. And mental health evaluation. My findings and recommendation will be forwarded to the board. You will receive official written decision from the board. Your board review is scheduled on October 3rd. The board may lessen my recommended sanction, let my recommended sanction stand, or impose a sanction longer than what I have recommended. If the board chooses to impose a sanction longer than what I have recommended, then a supplemental hearing would be held at that time, at the time that they schedule you for one. Okay, so this does conclude your revocation hearing at this time. October 3rd. All right, thank you.
Thank you.
I think he might be big mad. Big mad. She's...
Oh, you had no doctor.
Bros it came from TikTok. Hey, thank you, Jordan. Highly appreciate it.
Regarding Jonathan Morales, inmate number 395889, his hearing is being continued to October 1st, 2024.
I want to see his face. Hey, jump on YouTube, and it's you'll be able to see his face on. Hey, remember, ladies, if I'm not mistaken, I heard the parole agent said that he was single, but I guess that only means that he's not married. But M-Star Media, no whammy. Yeah, hey, like running to YouTube. Hey, gracias V, highly appreciate it. Yeah, so it's at Collect Call From on YouTube. We got about how many people do we have on YouTube right now? Let me see right now. We got how many? Let me see. We got about 34 people watching on YouTube right now. Remember to hit that like button as you come in. Hey, thank you, Mad Max. Highly appreciate it. Appreciate that. Jordan writes, October isn't far out, less than a month. Hey, we already have some pending. We got some pending cases for October already. We have October 4th for that one gentleman that has to come back. So it's October is definitely going to be not only Halloween, but we got a lot of parole hearings coming up. Let me say, Jay, sign me up. Kids need stepdaddy, and I need that love after a lack of fame. That's right. I was telling my wife, I was like, hey, we're gonna have to start a collect call from love after lockup. Yeah, get that going. That's gonna be the next move right there. Let me see what do we have over here on. See what we got over here on TikTok. Any of the comments? And for those of you that are on TikTok and are worried about missing out on the comments on TikTok, no need to worry. I actually have the TikTok comments up on the YouTube screen, so you can still read the comments that are being put on TikTok, if you will. Let me see here. Redbeard put he was about to throw a fit. He was ready. Yeah, his fists were ready to go. Please do Henry first. Oh man, hopefully they start up this next event pretty quick. Hey, thank you. I see we're up to 39 viewers now, and if you came over from TikTok, you might be like, damn, he said I could see on the screen over here. But so right now what they do is sometimes they'll put the camera on a timeout while they get ready. So we're just waiting for the next individual to come in, and once they come in, then they'll go ahead and start. And thank you, M-Star Media. I really appreciate it. She told them, yeah, she did, right? She told them, sit down. Like, hey, like you don't run this show. We run this show up in here. As a matter of fact, if I was him, that's definitely a bad look. You don't want to do something like that in front of the board, because pretty much they could decide when you go home or not, and they're gonna remember that you got up and you threw a fit next time when you come in. So you're definitely gonna have 2 strikes against you on that one. They might hang you out and make you do your whole sentence. So I mean, maybe he didn't want to go home. Maybe that's why he did it. You don't know what kind of situation he had on the street. So maybe he didn't have anywhere to live, or he didn't have any family support. So maybe he did that on purpose. So let me see if you're James. If you're using the word TikTok, they ban. Oh, okay. Oh, I was not. So, okay. I'll go ahead and I'll keep that in mind. All right. Hey, thank you for the heads up. Jordan, the board decides your fate for sure. They're going to push him out like 2 years, I bet. Needs anger management. Yep. Yeah, he doesn't. He obviously didn't think that out. Or maybe he did. Like I said, maybe it was his intentions, to get pushed out, whatever, maxing himself out. Let me see. Mad Max, they hold his future in their hands. You can't get crazy with the parole board. Yup. Absolutely. But you know what? I think that's one of the main reasons a lot of individuals end up incarcerated, because they don't fully think out their actions. You're just living in the moment and not realizing that till it's too late. Till you're in the back of that cop car and in front of that judge, that your actions got consequences. It's always best to take a moment, step back, and think about your actions and see where those actions are gonna lead you. Because one moment of not thinking correctly, and you're gonna be losing years of your life. Especially if you're in one of those states like Texas that they don't play around. I've been watching some of those hearings from Judge Boyd, man, and she be breaking those people up. She gives them chances, but if they don't come correct, man, I've seen some people that she'll break them off, like she'll max them out 8-10 years for possession, and I'm like, damn, and young too. I wouldn't want to go to the TDC, Texas Department of Justice. Hell nah, I'm straight. Let me see. So Jack, if you look right above my head, right here, right there, just hit that right there. At collect call from. Bam, and it'll come up on. It'll come up. It's also up here in this little picture right here. I'm trying to get my finger up there, right there. Boop, boop, boop. So yeah, for those of you interested in seeing the actual video, there it is. I'm highlighting it with my finger, slow motion. Ah, damn, what's up with this hearing over here? Let me check. All right, let me try to speed things up around over here. Let's see over here. Man, they're taking a long break right now. Don't they know people have to go to work? Damn, it's 9:01 already. My day's definitely been flying by today. Let's see, I'm trying to figure out how far back we're ahead, how much of a delay that we got over here. Just bear with me here. I'm looking at
my findings, which will be based off of the available evidence.
There we go.
Do you have any questions about the purpose or procedure before we begin?
No, I don't.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney and may hire your own attorney. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing or proceed without?
Without.
Don't do it. Don't do it.
You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, I do.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Charge 1, residence. On September 4th, 2024, around 9:16 p.m., residential supervisor McFadden witnessed you walk out of the front door of your only approved parole residence at Chase Center Halfway House. She followed you and asked if you were leaving. You stated yes and told her thank you. R.S. McFadden reported that you were upset around 7:15 p.m. to 7:45 p.m. You disclosed that you called your pregnant girlfriend and saw that she was high. The PO attempted to locate you by calling your cell phone and your mother's cell phone, but was unsuccessful. Neither you nor your mom returned this PO's call. Your whereabouts in the community were unknown until Wilton PD located you on September 6, 2024, after receiving a call from your girlfriend suspecting you overdosed. You were unaccounted in the community for approximately 48 hours. Your actions violated your conditions of parole, specifically release directions. I will live in a residence approved by my parole officer. The state has filed the following exhibits. Exhibit A, remand to actual custody. Exhibit B, parole violation report. Exhibit C, PCS signed conditions. Exhibit D, halfway house agreement. Exhibit E, Connecticut DOC PCS incident report. Exhibit F, Wilton Police Department report. Exhibit G, parole violation report. Exhibit H, notice of parole violation. Exhibit I, notice of parolee rights. And Exhibit J, Norwalk Hospital, which is pending, which we did not receive that. Mr. Dennis, did you receive the notice of parole violation report, and the other documents that were just marked for identification purposes? It should have been in the parole package. So you did.
Yeah, I got it. Yeah.
Today we have no witnesses, and it is now your opportunity to respond to the parole charges against you. However, remember that you may remain silent if you choose to do so. Would you like to respond to the charges at this time?
Yeah, I'd like to say something. Regarding with my girlfriend and the incident that is in the report, that was a misunderstanding on my behalf. The halfway house where I was residing at, I had a safe, sober place to go to, but parole officer I had before wanted me to go to a halfway house. It was in an area what I'm very familiar with that I used to get high in. When I got to the house, it was just a bad environment. There was people doing drugs. It just wasn't a good environment for me to be in. And I take full accountability for what I did. But I'm asking you guys, I have twins due in a couple months, a boy and a girl. They're my first. And when I left the house, I did use. I relapsed. I overdosed. I just want help, I want to be able to be there for my kids and my family. And that's all I have to say. Thank you.
Thank you. On charge 1, residence, I make a finding of probable cause based on state's exhibits B, C, and E. I find that the acts are serious enough to warrant revocation, and I have also determined that you should be detained while you await your revocation hearing. So that means your revocation hearing will be scheduled within the 60 business days from the time you came in. Okay, so you're going to get a written decision giving you a tentative date of your next hearing. And while you wait your hearing, you're going to remain incarcerated, okay?
Okay.
Right, thank you.
And what the board's going to decide what to do with me?
Yeah, so within 60 days, you're going to be scheduled for a hearing and for your revocation hearing, at which time you will come back before a hearing examiner. And then at that time, the board will have a final decision on what the appropriate sanction would be. at your revocation hearing. So again, you're going to get something in writing from today's hearing and informing you of a tentative hearing date for your revocation. Okay? All right. Thank you. You're all set. Thank you.
Yep.
Good afternoon. We can start with Mr. Aveles if he's available.
Mr. Aviles?
Yes.
Sounds good.
Thank you.
What happened? That was fast. I stepped away for 2 seconds and they denied him already? Damn. That was a weak statement. Let's see. Mad Max wrote he didn't sound like he wants to get out. Hey, maybe sometimes that is.
Hi, Mr. Aveles. We'll get started with you in just a few moments, okay?
Hey,
Okay.
welcome, Connie. Thank you for joining. Let me see.
Pearson, you can end Bridgeport's stream.
And Mad Max writes, James, this is awesome, bro. I'm glad you're getting so many viewers on. Yeah, you deserve it, bro. Hey, thank you, highly appreciate it. I appreciate you guys. You guys been right here with us since the beginning. I wouldn't be surprised if you were like the top 10. When subscribers. When I started the YouTube channel, it's definitely been it's a learning curve as far as what people like, and it seems like these board hearings, a lot of people are interested in hearing them. I am. So let's see. Oh, what? How'd that happen? All right, let's see over here on TikTok. Good morning over here to KJ on TikTok. And let's see.
Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Raul Aveles, 384-237. Today is Monday, September 23rd, 2024. This hearing is being conducted via video at the Board of Pardons and Parole, Central Office in Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Raul, my name is Raul Miguel Aviles Morales. My inmate number is 384-237.
Ching Gators, that was a
This
long
is a
ass
public
name.
hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Mr. Aviles.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to oppose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Aveles, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. First, I will read your rights. Then we will review the parole violation charge that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. You understand these rights?
Yes.
Thank you.
Hey, thank you, Cindy, for that
We now
confetti.
review the charges that the state, your officers, bringing against you and the information underlying each charge. Charge 1, obedience to the law. Violation 1. On April 17, 2023, you were mailed a 90-day address verification letter from the Sex Offender Registry, which was required to be returned by April 27, 2023, and you never returned the verification letter. On April 28, 2023, you were mailed a notice of violation letter from the Sex Offender Registry, which was required to be returned by May 8, 2023, so you could return your registry status to end compliance. You returned the signed notice of violation letter on May 19, 2023, postmarked on May 16, 2023. Violation 2, on July 17, 2023, you were mailed a 90-day address verification letter from the Sex Offender Registry, which was required to be returned by July 27, 2023, and you never returned the verification letter. On July 28, 2023, you were mailed a notice of violation letter from the Sex Offender Registry, which was required to be returned by August 7, 2023, so you could return your registry status to in compliance. You returned the signed notice of violation letter on August 4, 2023, postmarked on August 2nd, 2023. Violation 3, on October 16, 2023, you were mailed a 90-day address verification letter from the Sex Offender Registry, which was required to be returned by October 26, 2023. You returned the verification letter on November 8, 2023, postmarked on November 6, 2023. Based on your actions, you were arrested by Willimantic Police Department on July 11, 2023, for 3 counts of failure to register charges. This is evidenced by Exhibit E. The state has filed the following exhibits. Exhibit A, signed conditions of release. Exhibit B, remand to custody. Exhibit C, parole violation report. Exhibit D, notice of parole violation and parolee rights. And Exhibit E, Willimantic Police Department report / arrest warrant. The state found an addendum to Exhibit C, which states on August 1st, 2024, Mr. Avelos was found guilty of failure to register on all 3 counts and received a 30-day jail sentence. Counsel, did you receive the notice of parole violation report, and other documents that were just marked for identification purposes?
Yes.
Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses, and it is now the defense opportunity to present evidence and speak to any of the evidence submitted.
Thank you. Just in regards to charge 1, obedience to the law, I would just indicate that the addendum was stated correctly, and that the 30-day sentence that my client received has been served as of August 11th of 24. And again, I think it's unfortunate that these warrants were not served on him. Previously, he had a prior violation where he was the subject of the same charge, where he went to a revocation hearing and was sanctioned. And then subsequent to that, he was served with these additional warrants. Nothing further as to the charges.
On charge 1, obedience to the law, I make a finding based on state's exhibits A, C, and E. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel?
Thank you. My client's 31 years of age. He's single, but he is engaged. He has 2 stepchildren. He does have his high school diploma. He received a Pell Grant and attended school through Unified School District. So he has completed some college credits. He was living previously in a Reach apartment in Norwich, and then moved to Willimantic, where he was self-sponsored. At that point, the building was sold and he was staying in a motel. Because of the move, he was having difficulty receiving his mail and maintaining his compliance with the registry. I would just note that it's not as if he was completely avoiding contact with the registry. All letters were returned. However, they were returned, which in a time period that was considered to be late. As I previously indicated, he was remanded to custody on February 20th of 24, and he never left custody. His prior violation consisted of being charged with the exact same thing. He was given a 4.5-month sanction, and he was due to re-parole, but he never left because these warrants were then served on him. So he's now been in custody for over 7 months. In my opinion, on this violation, as I indicated, I think it's unfortunate that these warrants were not served on him previously, so that he could have addressed these all at his first revocation hearing. I would note that during this time period that he was in the community, he was gainfully employed working at Asplin Tree Service. He successfully completed the connection treatment for problem sexual behavior, including passing all lie detector tests, and that includes successfully completing all phases of that programming. Upon his reinstatement to parole, he's asking to be sponsored. Let me just double check, because I last had that you wanted to go to the Middletown area, correct?
Correct.
For halfway house, okay. And then he can return to his employment working at the Asplin Tree Company. And again, we would be asking that he be paroled immediately based on the fact that he previously had a violation. It was the same conduct. These warrants were in existence at that time. However, they weren't served on him until afterwards. He's been in custody continuously for the past 7 months. He did receive that 30-day court sentence, and it's been served as of that August 11th date. So we would be asking for his return to the community immediately. Thank you.
Thank you. I recommend a revoke and re-parole on October 3rd, 2024, which is an approximate 3-month sanction from the date of last release. Although you haven't physically left, that was the day that you were supposed to be re-paroled. So October 3rd, 2024 is my recommendation with the following conditions: no contact with victims, IP, no contact with minors without the express permission of your parole officer, halfway house placement, mental health evaluation, and problem sexual behavior treatment. My findings and recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on October 3rd, 2024. The board may let my recommended sanction stand or impose a sanction longer than what I have recommended. If the board chooses to impose a sanction longer than what I have recommended, then a supplemental hearing would be held. Before that hearing, the board will provide you with a written notice documenting the specific reasons why they might want to exceed my recommendations. Okay?
And if I just place on the record that he previously has permission to have to be around his 2 stepchildren. That's already been approved. That had already been approved by his parole officer. I don't know if he'll have the same parole officer when he returns to the community. I just want to place on the record that had been previously approved. In addition, he has already completed the problem sexual behavior treatment, and in fact, this should be noted as well.
Okay. So I will make a note of both, and so prior permission to have contact with 2 stepchildren.
Correct. That's correct, right, Raul?
Yes.
Yes.
Okay. You are all set. This concludes your revocation hearing.
I have only one question. Am I having another hearing on October 3rd, or is that my release date?
So it's the board review date and your release date. So as long as the board accepts the hearing examiner's recommendation, you will leave that day. If for some reason the board says we don't want to accept that recommendation and we want you to have a longer sanction, then we'll be notified in writing that they want you to have a supplemental hearing. Okay, so hopefully that's not the case and you do leave that day.
Okay, thank you. That's
Okay.
it.
Okay.
Yes.
You won't go to the board review. You don't go, I don't go. I just watch it.
Okay.
Okay.
All right.
All right.
Thank you.
Thank you. You're welcome. Good luck, sir.
Thank you.
Hey, that was all bad right there, man. I was listening to it on the background.
How's it going?
Good. Is Mr. Zacharo available?
Sure did. Yeah. Zacharo.
Yeah, there is. There's a lot of them. It's scary out there. Hey, if you're watching on the TT side, I would suggest for you guys to jump over on the.
Good morning. My name is Professor Saunders.
side.
I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Michael Zacharino, 365116. Today is Monday, September 23rd, 2024. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Robertson Correctional Institution. Please state your full name and DOC inmate number for the record.
Michael Zacharo, 365-116.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit on behalf of Mr. Zacharo.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony of today's hearing will be taken under oath. Mr. Zacharo, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, I do.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yeah, I do.
We now review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. On charge one, on charge one, reporting. On April 5th, 2024, you failed to report to the Waterbury District Office as directed by your parole officer. Subsequently, you are in violation of parole by condition number 1, release direction. Charge 2, GPS. On March 22nd, 2024, your GPS was dead. You were told numerous times to charge your GPS, and you stated you were going to get the charger and would charge it. As of May 2nd, 2022, you failed to charge your GPS as directed. Subsequently, you are in violation of parole condition number 1, release direction. On charge 3, program participation. On April 19th, 2024, you were placed in App Foundation inpatient program in New Haven. On April 22nd, 2024, you left the residential inpatient program and did not return. You were unsuccessfully discharged from the App Foundation. Subsequently, you are in violation of parole condition number 1, release direction. Charge 4, absconder. On April 22nd, 2024, you left the App inpatient treatment facility in New Haven without prior permission from your parole officer. You are not residing at your approved parole residence. You failed to make any phone contact with your parole officer after April 29th, 2024. Subsequently, your whereabouts are unknown at this time. You are in violation of parole condition number 1, release direction. Charge 5, obedience to the law. On April 14th, 2024, you took 7 cases of Red Bull from the Target store in Orange without paying for them. Orange police attempted to stop you and you tried to take off on foot. You were detained by Orange police and charged with larceny 6 and interfering with police. Subsequently, you are in violation of parole condition number 2, obey all laws. On May 30th, 2024, you were arrested by New Haven police for interfering with police and theft of a vehicle. The state has filed the following exhibits. Exhibit A, parole conditions. Exhibit B, remand to actual custody. Exhibit C, notice of parole violation. Exhibit D, parole violation report. Exhibit E, GPS monitoring agreement. Exhibit F, Orange police report. Exhibit G, app unsuccessfully discharge report. Exhibit H, Allied Universal EM report for last on GPS point. And Exhibit I, New Haven Police Incident Report. The state has filed an addendum to Exhibit D, which states on August 1st, 2024, Mr. Zacharo was found guilty of larceny 6 and interfering with an officer. He was sentenced to an unconditional discharge under docket ending in 785. on August 5th, 2024, Mr. Zacharo was found guilty of interfering with an officer and was sentenced to 5 months jail under docket number ending in 182. The charge of theft of a vehicle was not pursued. Counsel, did you receive the notice of parole violation report, and the other documents that were marked for identification?
Yes.
Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. They have no witnesses, and it is now the defense opportunity to present evidence to speak to any of the evidence submitted.
Thank you. In regards to charge 1, reporting under release direction, we would submit there's insufficient evidence to support this charge. There's no evidence submitted of a reporting schedule, and my client maintains that he was not aware of this reporting date. He only reported in person at the parole office on one time, and that was to remedy a faulty GPS monitoring. His typical meetings would occur with his parole officer. He reports in Meriden at Dunkin' Donuts, and that was on a monthly basis. He had progressed from meeting the parole officer bi-weekly to meeting monthly. He was not aware of April 5th, 2024 as a reporting date. As I indicated, I don't see anything submitted that he should have been aware of that date. In regards to charge 5, addressing charge 4 absconder, I would just note that my client did contact his parole officer to indicate that he had left the program, and then he was re-referred to the program, but was subsequently arrested. In regards to charge 5 under obedience to the law, the addendum was stated accurately on the larceny 6 and interfering in the Orange jurisdiction. He received the unconditional discharge on that particular file. And then subsequent to that, he did receive the 5 months to serve on the interfering. My only question is if you could confirm with me his end of sentence date on that. It was unclear if the court gave him his jail credit.
I'll just confirm docket ending in 182, correct? Yes. Yep. For the 5 months sentence. So his end of sentence is January 4th, 2025.
Thank you. Nothing further as to the charges.
I'm going to take a moment before I announce my findings. On charge 1, reporting, I make a finding based on state's exhibits A and D. On charge 2, GPS, I make a finding based on state's exhibits A, D, E, and H. On charge 3, program participation, I make a finding based on state's exhibits A, D, and G. On charge 4, absconder, I make a finding based on state's exhibits A, D, and G. On charge 5, obedience to the law, I make a finding based on state's exhibits A, D, F, and I. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel?
My client is 33 years of age. He's single. He has no children. I believe this is his first violation of parole, and that he was in the community for approximately 8.5 months prior to the violation. During his time in the community, he indicates that he was working 2 jobs. One working at Rockland Fencing, which is located in Middlefield, Connecticut, as well as working at Roberts Chrysler and Dodge in Meriden, both for full-time positions. The fencing company, Rockland Fencing, he indicates was a seasonal job. He was employed up until the time of his remand, and he was sponsored by a sister in Meriden in the community. Also, during that time period that he was in the community, he was attending Wheeler Clinic for treatment. He was attending that virtually. He was drug tested at Quest Lab once a month. He did not have any dirty urines, and he always showed up for those appointments. His parole officer did feel as though a referral to APT was warranted based on, I guess, a feeling that she thought that he was relapsing. However, he disagreed with that and denied that. He had a level of frustration with that referral and obviously made a bad choice to leave the facility. However, he did notify his parole officer that he did leave the facility. He was prescribed in the community medication-assisted treatment in the form of methadone, and that was prescribed by the APT Foundation, and he picked that up daily there. Since his remand to custody, he's also receiving medication-assisted treatment in the form of methadone. He participates in medication-assisted treatment groups on a monthly basis. He's been in custody now for approximately 3.5 months on this violation. He indicates upon being re-paroled, he'd like to be placed in a halfway house, first in a New Haven area, and as a second, he would like to be placed in the Hartford area. He eventually would like to secure a sober house. However, we did discuss the difficulties with doing that when he does not know an exact re-parole date, but he would like to secure that at some point. He can return to his employment at Chrysler Dodge in Meriden, as well as the landscaping position in Middlefield. He is amenable to all treatment recommendations, and with the understanding that he has to follow all of the recommendations of his parole officer, whether or not he agrees with them or not. He does understand that. I had a conversation with him in regards to that. He also spoke with my social worker at length in regards to that as well. I would just note that there's no graduated interventions or sanctions listed here, and that the parole officer did not make a recommendation. I would be asking for a re-parole date in line with his TS eligibility date on the 5-month court sentence. Thank you. Again, it's his first violation.
I recommend revoke and re-parole on January 6, 2025, which is an approximate 7-month sanction, which coincides with Mr. Zacharino's end of sentence on his new probation.
Wait, you said it was January 4th?
Yeah, it's the weekend. It falls on the weekend,
Oh,
so
okay.
January 6th is the
Okay.
Monday. Yep. Okay. While this is Mr. Zacharino's first parole violation, he received 2 additional convictions while on parole. His whereabouts were unknown for about a month as he evaded parole supervision, and he failed to engage in substance use treatment as recommended. I recommend the following conditions: adjournable contact with Penny Bolin, Josue Moreno, and Eliud Gonzalez, halfway house placement, and mental health evaluation. My findings and recommendations will be forwarded to the board. You will receive the official written decision from the board, and your board review is scheduled on October 3rd, 2024. The board may lessen my recommended sanction, let my recommended sanction stand, or impose a sanction longer than what I have recommended. If the board chooses to impose a sanction longer than what I have recommended, then a supplemental hearing would be held. Before the hearing, the board will provide you with written notice documenting the specific reasons why they might want to exceed my recommendation. So this does conclude the revocation hearing.
The sanction then is
approximately 7 months, yes.
Thank you.
No problem.
I have no further questions. Do you have any questions, Michael?
I do not.
Okay. So do you want to call me after October 3rd to know if the board accepted the recommendation? Okay.
I do.
Okay. All right. Good
Thank
luck.
you very much. Have a good day. Thank you.
You as well.
Hi, should we just, Mr. Kwicki?
Yep. So right in. Kwicki, go ahead.
Six days. Miss Jones. Hey, how are you? I'm gonna move up a little bit. Yeah.
That's fine.
Neither I'm a deaf.
Yep. So we're gonna pick up right where we left off.
Say again?
We're gonna pick up right where we left off from your last hearing.
Yeah.
We had to continue
I
it.
can't believe it was 7 days ago.
Yeah, so what we're gonna, I'm going to just reintroduce you on record, and then we're gonna pick up right where we left off, okay?
Okay, yep.
So again, good morning, my name is Per Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a continuing preliminary hearing for Andrew Kwicki, 141235. Today is Monday, September 23rd, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Robinson Correctional Institution. Please state your full name and DOC inmate number for the record. I just need you to say your full name and your DOC number, your inmate number.
Andrew Kwicki, 141235.
Yep. So at the last hearing, I read you your rights. You said you understood your rights. You were under oath at that time, and I was about to announce my findings. You testified already. So where we were leaving off is that I'm making my findings based on the charges against you. Okay.
Right.
So for charge 1, program participation, I make a finding of probable cause based on Mr. Kwicki's testimony as well as state's exhibits B, D, and EE. On charge 2, employment and community service, I make a no finding of probable cause as the state failed to provide sufficient evidence to prove that Mr. Kwicki's actions meet the elements of this charge. On charge 3, halfway house placement, I make a finding of probable cause based off of Mr. Kwicki's testimony as well as state's exhibits B, D, E, W through Z, AA, and CC. I find that the acts are serious enough to warrant revocation, and I have also determined that you should be detained while you wait your revocation hearing. At the revocation hearing, a hearing examiner will determine if you violated the conditions of your parole. If so, the hearing examiner will make recommendations regarding whether your parole should be revoked and what, if any, sanctions should be imposed. So, Mr. Kwicki, your revocation hearing is going to be scheduled within 60 business days from the time you came back in. So you're going to get an in writing of a tentative date of when your next hearing is. Yeah. Okay? Okay. So you're all set. This concludes your preliminary hearing.
Yeah.
Okay. So you're all set. Thank you.
Yep. All right. Okay. Have a good one. Have a better circumstance next time we'll meet. Dinner's on me.